Welcome to a special episode of Conduct Detrimental. I am Dan Lust, sitting alongside my buddy, producer extraordinaire, Mike Lawson. What's up, bud?
Dan, how's it going?
It is good. It is good. So as many of you know, we did a live Twitter Spaces on Twitter, and we're definitely going to do more of these in the future. That went incredibly well. So we convened on Tuesday for a 2.5-hour session. We dropped every single nugget that we've learned about Deshaun Watson over the last year and a half. We gave every single scenario. We took people from the crowd. We got slightly bombed by a Baltimore Ravens fan, but by and large, some really good questions from Browns fans, Texans fans, and a lot of new listeners, a lot of new followers popped in. So we said, what are we going to do with this audio? It's so long, and enough people in our feeds and our DMs said we should release it. So that's what we're going to do. This came from Tuesday after day one of the hearing, and obviously the hearing has gone on now Tuesday, Wednesday, Thursday. Really the only updates, and Mike, you and I were talking about it, right? There was a leak at one point that the NFL might have accepted 6 to 8 games. That has since been debunked. And the other thing that is new, that is important, after the third day of the hearings, the Sue Robinson said, I want to accept briefs. She's going to accept briefs up until I think it's July 11th. And then there's really no timetable on a decision, maybe a couple weeks, maybe a month, but I still think it's within that time frame of the summer. So, Mike, before we kind of talk about the highlights of the audio, before we go to it, what were your overall thoughts of the Spaces? I mean, I thought it was a lot of fun.
I thought it was wonderful. I mean, it was a great get for Dan to bring in Josina Anderson.
Josina.
She brought in a ton of knowledge and a great insight into the hearings. I think we were expecting more. I think maybe more news out of the hearings than what we've actually gotten. Besides maybe the 6 to 8 game thing that you just mentioned. I think we're looking at the NFL is probably hoping for a 1-year suspension. What we've been talking about this whole time in terms of a decision, I think. We've had Watson coverage for since it started for over a year that we've been talking about.
Year and a half.
Watson. We've had a lot of episodes dedicated to Watson and the developments of Watson. And I think one thing that I think kudos to Dan said the whole time is if there was going to be some sort of hearing or some sort of suspension that was coming down, it was going to be before the season started. So Watson could get his due process where he could go through his appeal process to potentially have that suspension lessened. So we wait and see what Sue Robinson's decision is going to be. But I thought it was great in terms of the Twitter Spaces. I thought it was a great avenue for us. We had a lot of people in there at the time live. I think we had about almost 2,000 people come in and out throughout the 2.5 hours. So I think it was a great venue for us and a great overall conversation.
So a couple of things, and you reminded me first, big thanks to Josina Anderson. She was a huge guest, former ESPN, CBS. She's just a fantastic guest, and she's been pretty knowledgeable here. One of the reports that's come out in the past couple of days, I'm not sure, who was leaking this, whether it's the player side or the NFL, but apparently Judge Robinson, the judge presiding over this, was not happy with the leaks that have been, coming out over the course of this case. So we heard a lot of leaks leading up to the first day of the hearing. Obviously, you're going to hear our audio of a recap of that. But the leaks were that the NFL wanted a year, that they were negotiating, and then the NFL wanted an indefinite suspension. So Robinson, at least the news that trickled out, was that these leaks appeared to be favorable to the NFL when they were coming out. So, we haven't heard any leaks since then. So both sides buttoned it up. The only other part that I wanted to bring up, and Dan, we should mention, Dan Wallach is not with us tonight. He is alive and well. Don't worry. He is totally fine. But, we've been doing a lot of radio across the country, Cleveland. I did Blacksburg. I don't know, you name a city in our country, Dan and I have probably done media in it. I think it was, a lot of this is just going to be the same stuff we did in the Spaces. But, Mike, you and I wanted to come here. I did want to say, Dan, I've been watching Dan's feed today. Dan has been pretty vocal on a front. I don't think he was as strong on this when we did the recording on Tuesday. But the fact that Watson has already kind of served a de facto suspension last year, obviously he was paid, but he wasn't able to play. Mike Florio had an interesting suggestion, right? Watson sat out all of last year, but he was paid. So Florio gives an interesting suggestion. I don't necessarily know if I'm in favor, but it's interesting that Watson should pay back that money that he earned and basically get credit for time served for a year. Let's just say it wasn't the most popular suggestion, but it's an interesting one. I don't know, Mike, but before we get into the audio, which we keep alluding to, which I think is really good. Thoughts on this time served thing? Dan seems to be in support of it. Florio seems to be in support of it. I've made the point on the show, but as we've gotten closer, I'm like, I don't know. The guy preserving himself for a trade. I mean, he kind of was a holdout, if anything.
We'd have to know why he didn't play, right? I mean, because we just don't know why he didn't play. He wasn't on the banned list. Was it the Texans holding him out? Was he not suiting up to play? I mean, he was ready to play. He was eligible to play. There was no reason why he shouldn't have played, but I don't think anybody knows the reason why he didn't play. So I think if it was the Texans that said we're not going to play you, then yeah, maybe that's kind of like a suspension per se. But the NFL didn't ban him. He wasn't on the banned list. He didn't have any issued decision for a suspension. He was just kind of stuck in limbo. So I guess it would depend on if Watson's camp comes out and they want to make a push for that. I don't know if they could retroactively even do that. That would set a new precedent that I don't think the NFL wants to dip their toe in.
Speaking of new precedent, and we'll just go down this rabbit hole, and then I keep alluding to the audio is good here. You're going to get a complete deep dive and masterclass of Watson, but someone in my DMs has that theory, and essentially that the NFL and a lot of leaks have come out that the NFL does not want this process to go through the appeals. They don't want to put Roger Goodell in a tough situation to look bad, to just, agree with the NFL's, year or the indefinite period, or the other appeal, right, to the federal court. The NFL doesn't seem to want that. And again, you want to go down this rabbit hole of a tinfoil hat. If there is a very, a public appeal, there is a chance that whatever was agreed to behind the scenes, I do think something was agreed to, either between the Texans and Watson, or the NFL and Watson, something, right? I do think that's at risk of coming out. So, we could get to the bottom of it. But in any event, it's been Mike, it's been a long and busy week. We're going to stick just to Watson in this episode. The next episode in our feed, we did a lot of Freddie Freeman. We did a lot of Major League Baseball arbitration, a lot of NIL, and the USC, UCLA vault. It's been a very wild week. So if you're listening to this episode and you enjoyed our Watson conversation, please tune into the next episode. Rate, review, subscribe, all things conduct detrimental. Obviously a lot of new listeners for this episode. And we hope you stick along for the sports all right. Obviously, been pretty busy 2-3 weeks for us, but upwards and onwards, Mike. Okay, podcast becoming anew, sponsored by Underdog Fantasy. Use our promo code Connick for a $100 match bonus. Obviously, Underdog, you will have heard of them from having best ball fantasy. The football season never ends, even though we're not playing games right now. Football tends to be king in these parts, especially on our show, Conduct Detrimental, as a show about, at least a show that was started about football issues. That's where the term Conduct Detrimental comes from. We had a lot of fun. Over under, if anybody wants to guess, I'll set it at 3.5, the amount of times we say the word conduct detrimental in the spaces. But if you're into gambling, you're into DFS, check out Underdog Fantasy, use our promo code conduct. So without further ado, we will kick it to our full Twitter spaces with our guest, Josina Anderson. And here it is. Where were we? We were breaking down where we're at. So I think everyone that's in here was listening to our initial breakdown. Where Dan was going right as we got cut off, I was explaining that today is day one of the hearing. It has since been adjourned. It was no guarantee that it would be adjourned until tomorrow. I don't know if we've received confirmation on that. But what I think we've got word on is that the hearing will continue on consecutive days until Thursday. So it looks like the reports are that it will go today, tomorrow, and the day after that. There is optional briefing, as Dan said. There's not always a guarantee for briefing. Sometimes in the NFL hearings, the judge allows it, and I would think they would allow it here. And for those that missed the initial part, again, the hearing is occurring in Delaware in front of Judge Robinson. Dan, I will send it to you on Twitter, but go ahead, give your announcement.
Yeah, forget text messages. Let me just kind of, Josie's waiting for the new link. She's going to join us any second. One thing about the briefing, Judge Sue Robinson is a longtime federal court judge, and when you appear in front of federal judges, you normally file briefs before the hearing, sometimes post-trial briefs. They're not permitted in NFL disciplinary proceedings under Article 46, but there's a provision in which if the parties agree to it or the hearing officer wants it, then it becomes part and parcel of the hearing, and you got to file it within 3 days. It's limited to 5 single-spaced pages. So that is something that we're going to expect at some point post-hearing, and the hearing could end Thursday, so the parties may actually submit written briefs by early next week. Thanks.
So, that's Dan's cue, because we are working again on some technical stuff here. If you guys like this, we'll obviously do more of these.
You got to tag Josie. I don't know how to do this.
Dan, you know how to send tweets. Come on, don't
it's not in a tweet.
Short.
It's not in a tweet. Please hook me up here.
You can mute. Meanwhile, I'll explain where we're at
with
some other stuff. Okay, so
Again, thank you everyone for rejoining us. We got a lot of people in the first one, but I think we're going to hang for probably about an hour. And if anybody is joining late or has never heard of us before, we host a podcast called Conduct Detrimental. We talk about all things sports and law, and obviously the Watson case we've been covering for a year and a half. So Dan and I have been on we'll say the virtual version of Radio Row this week. We've been going on all different shows and answering a ton of questions. So Dan called me today and said, should we just do a version of the show live on Twitter? And I said, of course we should. That is a great idea. I think we should talk probably about timing, as we'll give Dan a minute to get himself set up. The big update this last 2 weeks, we had two of them. Obviously, Watson settled 20 of 24 cases. So he's got 4 remaining. There was a report probably about 2-3 weeks prior that there would be a 25th and a 26th case added to the civil docket. Those have not yet been filed, and it's not clear if those 2 additional cases were part of that 20 of 24 settlement. Unclear at this stage. But we're talking numbers, right, guys? And I see, Josina, you're in the crowd. We're going to have Karen add you to the stage. I think we can do that. Yes, 5 accusers or 5 women are part of the case today. Dan, take it away. I'm going to figure out the tech side.
Josina, welcome to our first ever Twitter.
Here we go. I got it.
Okay.
Got it.
Oh, my God, Josina, it's been technical difficulties. I know we only have you for 10
That's
minutes.
All right.
Thanks for making some time available. Legendary NFL insider and co-host of The Crew. You and I known each other for a couple of years, so thank you for dropping by today, and it was probably your 20th appearance of the day.
It's okay. No problem. I mean, listen, this is a big topic right now in the NFL. It's going to be ongoing for a long time. It makes me think of all the cases that I've covered in 2 decades of covering the NFL, from Ray Rice, Adrian Peterson, Myles Garrett. I can't even name all of them. StarCats. We can go on and on and on and on. So I'm definitely not surprised that this hearing will go on for multiple days, and hopefully, assuming that we do get to a finding from Sue Robinson, that we will have some sort of idea of what argument she's paying deference to. You know what I mean?
Yeah. I want to ask you about that. I've watched your timeline, and your timeline and my timeline are almost like simpatico on the issue of disparate discipline. I mean, you highlighted a tweet from Roger Goodell that the personal conduct policy applies to everybody, owners, players, and you kind of highlighted the fact that Dan Snyder got a minuscule fine with a $2.5 billion net worth, and Robert Kraft and Jerry Jones were sued over sexual misconduct allegations. So where do you think this fits in to the calculus in the decision-making of Judge Robinson? Should it be relevant, and do you think she'll consider it?
It should be relevant because the application of the personal conduct policy applies more to just the players. So that invites the review of how it's being applied to personnel outside of the players. And I think, objectively speaking, when you're looking at Daniel Snyder get a $10 million fine, and I think actually Forbes has updated his net worth to $4 billion now, and that being 0.25% of his worth, no draft picks lost, and no suspension. I mean, that's basically akin to him pulling out a quarter out of the side of his couch. And so what impact is that? I mean, it was so minuscule to him that the fine was donated to charity, right? And then when you're looking at that relative to the impact of a player potentially losing an entire season, when in the NFL, an entire season, as far as the regular season, can be 17 games, that is far more impactful to his season and the average length that an NFL player is in the league, in comparison to, objectively speaking, a $10 million fine to somebody that's worth $4 billion. And even though you point to day-to-day operations being taken away from Daniel Snyder and transferred to his wife, Tanya Snyder, do we really think that Daniel Snyder and Tanya Snyder don't talk when they get home?
Yeah, I mean, after all, he's in Cannes. He was evading this congressional subpoena, not available for service of process, and he's in France on "quote unquote" commander-related business, and all of his employees with the commanders are on this big yacht, and it just seems like it's a big sham. But I'm getting a lot of pushback on another issue. He missed all of last year, Josie, all of last year. 1 year suspension. People are saying, well, he made a voluntary decision to sit out. He had a trade request. But I think Roger Goodell exacerbated this by making no clarity around the commissioner's exempt list. I mean, he could have been traded at the deadline if his status had been clarified by the NFL commissioner as to whether or not he was going to be placed on the list. How much time do you need to make a decision like that? Do you think that factors in to the decision? Because if he's suspended for an entire year, Josie, it's now 2 years.
Dan, can I add something real quick? And
yeah,
Josina, I think I want to hear what your thoughts here, because it looks like you're very tapped into what's going on at these hearings. Dan, to Dan's point, and it's a point Dan and I have brought up a couple times on our show, and for those that are coming into Conduct Detrimental is our podcast, and the recording of this feed will be up on our podcast probably tomorrow morning. But Josina, what was interesting last fall, Roger Goodell was asked, is Deshaun Watson going to be put on the exempt list? And I'm paraphrasing, but he said that there was not enough at that time to put him on the exempt list. So from my vantage point, right, what has changed since last fall? The criminal charges did not proceed with two separate grand juries. And now all of a sudden, Watson's looking at a potential year suspension and an indefinite ban after that. Is that a topic that you've expected to come up at these hearings, that, maybe the hypocrisy that, he was not placed on the exempt list, and yet we're skipping that step and jumping all the way to suspension? It seems very odd.
So, a couple things. One, to clarify, when Deshaun Watson missed last year, that was voluntary. That was not a suspension. But the reason why the league didn't have to clarify, and you're right, they didn't, is because they weren't forced to, because he did not come on the field for the Houston Texans or for a team around which at the time, because he was a member, that the situation involved that team. And when you look at what the league's approach has been, at least over the last year and a half, 2 years, relative to kind of what they used to do and the wisdom they've gained, and what they learned from how they used to kind of get out in front of these situations, their desire has been to sit back, let kind of all of the officials weigh in, and then try to wait to the last minute before they really come in, as for the purpose of, I guess, absorbing less arrows for speaking too soon and getting caught with that. You know what I mean? Mm-hmm.
Josina, I want to go back for a second to the Dan Snyder, Jerry Jones, Robert Kraft issue. Is Watson's legal team or the NFLPA not only going to bring this up, but are they going to ask for discovery related to the NFL's handling of the investigation or lack thereof around these three NFL owners who were accused of, at varying points, sexual misconduct? Is it something they ask for to prolong these proceedings? Is she going to have to make a ruling here on their admissibility or relevance?
Can you ask the question again? So,
will the Players Association
rephrase, Mr. Wallach?
Will Deshaun Watson and the NFLPA, sorry for the compound question, will they be looking to gain access to investigative records or quiz NFL officials on any investigation or discipline regarding Jerry Jones, Robert Kraft, Dan Snyder? I think the linchpin of Watson's defense is going to be focused on the lack of fair and consistent discipline. Is he going to seek discovery or any kind of inquiry into the NFL's handling of those matters?
So procedurally, I don't know if they can get any additional discovery out there that's not available just via media reports. I mean, relative to Daniel Snyder, we know of the fine and the transfer of day-to-day operations. Relative to Jerry Jones, there were reports of, I think, maybe $2 million for conduct detrimental.
Josina, you said the word.
Yeah, there you go. For attempting to impact Roger Goodell's 5-year extension at the time, fighting on behalf of his running back Ezekiel Elliott. And then Robert Kraft, at least according to Yahoo, getting no discipline for the misdemeanor prostitution charges being dropped. And that stands out also because Roger Goodell has underlined time and time and time again that you do not have to be charged. You do not have to be charged, obviously, to receive any discipline, which also applies here to Deshaun Watson, because we know 2 grand juries have no-billed this thing, and there are no indictments. So that's why I do think one other point to highlight here that then you would kind of be a natural counterpoint rather, relative to what I just said, is how deferential Sue Robinson is to the fact that there are multiple women and multiple allegations at this total, though we know 20 of the, at least 24 at the time, have already been settled. So does she pay deference to the fact that there's this high total? Or is it doesn't matter how many people make accusations, everything has to be vetted and scoped individually, each litigant, each accusation, everything has to go under the telescope, and we see whether it bears out.
So I know Dan has a question about the settlements afterwards, but I have one question. In the world, obviously, we've been following this story very closely, and the Dan Snyder congressional hearings very closely, which are kind of dovetailing with one another. Josina, you had that great tweet, from Yahoo Sports, the quote from Roger Goodell from 2019 that said that everyone, right, owners, players, coaches, everyone has to adhere to the personal conduct policy. Now, what we have happening simultaneously, and you'd think this argument is being made right now in day one of the hearing, I would expect it to come up at Congress if and when Dan Snyder does appear. Dan Snyder, owner of the Washington Commanders, is accused of sexual assault, sexual harassment, and paying a $1.6 million settlement to make those cases, or that claim go away. I think the team is alleged to have paid it. So as far as I'm aware, the NFL's, we'll say, discipline to Snyder, that he has to cede day-to-day handling to his wife, Tom Snyder, for a period of time, and also this $10 million fine. I don't believe those suspensions were tied to this 2009 incident of the sexual assault, sexual harassment from Snyder. Now, I'm not going to put you in a position to kind of opine on that, but don't you think that the league's handling, right, that they're kind of caught with their hand, in the cookie jar, so to speak, the lack of a punishment to Snyder while Watson is, again, facing a 1-year suspension, it seems, again, somewhat hypocritical.
Well, I don't think that there's any, arguing that the league's approach to discipline has been all over the place when you just look at their history of recommendations. But nonetheless, each of those cases do represent some sort of precedent, though obviously all of these are, none of these are kind of apples to apples. They all stand on their own differently. But you still can't ignore, to be objective, the fact that the NFL has applied, at least with respect to the players, some sort of discipline. So that has to be acknowledged, because I'm sure, let's say, if Deshaun Watson were to get 0 games, or for some reason Sue Robinson says, hey, I don't even feel like I can come up with a conclusion because I feel like coming up with a decision would be prejudicial to his pending litigation. I'm sure someone like Ezekiel Elliott would be like, whoa, I got 6 games. You see what I'm saying? So you have that. Then you have the point that you're making with, the disparate discipline with the owners. And you're just kind of looking at the wide gamut of everything that has happened, from Kareem Hunt to Ray Rice to Adrian Peterson, Myles Garrett. I mean, the guy from the Cowboys whose name is escaping, Greg Hart. All of these cases that have gone on. I just think the last point to kind of underline all of that is that I feel like what I can say that connects all of those cases is that I do believe that Roger Goodell, assuming he takes this on if there's a violation deemed and he's not designating a designee for this, that he will have to consider all points, with respect to everything, in addition to PR, optics, past history recommendation, owner, what some of the female contingent might feel, what some of the other people might feel relative to rights when you're accused all across the gamut, and it is a very complicated case.
Okay. Josina, I know we're going to keep you to 10 minutes, and we'll let you go about one final question, unless you want to stick around, of course. You've tweeted quite a bit about settlement discussions between the Players Association and the league. I see this as an eminently settlable case because, an indefinite suspension doesn't make any sense. I don't think she's going to grant that. So why can't they find some kind of a compromise position between, 6 games and let's say 10 games or a season? There's got to be something where they can meet and just avoid the fallout from either an indefinite long-term suspension or the league having adverse precedent on issues relating to Snyder and Kraft and Jerry Jones. So can you update us on where the settlement talks were, where they broke down, and whether that is even possible at this point?
So the first thing I would say is, well, I don't know that Sue Robinson won't find for an indefinite suspension. She could say that if she is deferential to the fact that there are ongoing cases and she feels like it should be indefinite because of that. As I have also underlined that maybe she thinks that, a finding could be prejudicial while there are pending cases, and then go the exact opposite way and say, no finding. So I don't know where she's going to land. I've consistently said she's the X factor. She's going to be the flagpole on the spectrum of diametrically opposing arguments. And then from there, we're going to see on what side of the median we are. And then we can all pontificate from there where we'll think Roger Goodell or his designee will go with that. So I just think, we just kind of have to wait and see. Now, what was the second part of your question?
Will the parties settle? It makes all the sense in the world to settle because of the fallout from not settling.
Yeah. So I think that, per the conversations that I've had per sources, right? And people have asked me this. I always set it up first by saying this. First, going off of what Deshaun Watson has said himself on the record in public, saying that he feels like he has done no wrongdoing, though I still underline with that comment at the press conference for mandatory camp, he did express sensitivity to people being triggered by the fact that he said he had no regrets, and he did express that verbally, right? But now, having said that, to kind of set up my next comment, anytime that I've talked to sources around the cases, I have not heard any equivocation from that side with respect to confidence in their arguments and confidence in the case, and part of that includes what I also tweeted today, the expected presentation of mistruths that Deshaun Watson's side will purport in countering the allegations that are before him. So because of that, so why am I saying that? So because of that, this is why they're on the other side of the spectrum arguing with Jeffrey Kessler that there's no basis for a suspension. And then on the other hand, you have, per what the Wall Street Journal has said and the Washington Post has said, that the league is reportedly seeking this indefinite suspension, no minimum, no more, less than a year. So this is why, to answer your question finally, 10 minutes later, why they can't come to a settlement, because they are literally on opposite sides. And though there was a settlement with 20 cases of the 24, it wasn't indicative of their feelings, of their confidence, of their arguments. It was more a mechanical thing as far as realizing that there's an NFL calendar with the season, and, relative to how things were kind of coming down the pipeline, in contrast to what he was saying about not originally wanting to settle, obviously came to the conclusion that this was now in his best interest. But per my understanding, it's not a reflection of the validity that they are going to, present, that they feel they have in their arguments.
Wow. Thank you. Thank you so much. This was really enlightening, Josina. I'm so thrilled that you were able to finally join me on a podcast after all this time. I remember I asked you 5 years ago during the Ezekiel Elliott case, and you had some ESPN-related restrictions. So better now for the bigger story, I think. But I'm grateful you're able to join us. And I know it's been a long, busy day for
Dan,
you.
the good news is that this is not technically our podcast, so Josina, you might actually have to come on the real podcast. You've been so fantastic for us.
Well, listen, I always appreciate an intelligent conversation. I do think that there's a lot of nuance to this case, and sometimes that can't be best encapsulated, by a tweet. And sometimes when I'm tweeting things, people, well, why is she saying this? She's not saying this. Well, I can't sit up here and have a Shakespearean diatribe on Twitter. I'm just trying to kind of get out what's the next point based off of a series of tweets that I've already tweeted. So with that said, I do appreciate the conversation. I hope everyone has a good evening, and we will be back at this tomorrow with day 2 of the hearing.
Thank you very much, Josina. We're going to hang out and we're going to try to recap all the lovely things that you said for us, but really appreciate your time.
And
no problem. Thanks, guys.
Check out the crew on where is it available? Facebook, and where can our listeners?
I mean, as of right now, the show is in hiatus until the start of the next season. But prior to that, at least right now, you can go to thecrewshow.com to find old episodes, and we should be back if I have the energy to do everything that I need to do for the upcoming season. Okay, all right, guys. So thank you. I appreciate you all.
Thank you so much.
All right, take care.
Have a great evening. Bye now.
Too.
Thanks.
You too.
Okay, so for our first cases, Dan, we only have over or under 4.5 technical issues. It's not so bad. So I'm starting to get some questions in my DMs from the crowd. In lieu of having people come up, which I think we'll probably do towards the end, if you want to email Dan or myself, or both Dan, either of the Dans, message us questions. We're happy to answer them. So one topic that did not come up, and as we are lawyers, it's only fitting that we talk about some of the lawyers that are involved here. So, Dan, I know you have a lot of thoughts about Sue Robinson. And, Dan, you've done a deep dive into how she might rule based on some of her prior hearings. I think a name that we should bring up. Dan, you ready for this? Do you know what I'm about to say?
Jeffrey Kessler.
Jeffrey Kessler is brought in to represent Deshaun Watson. So, Rusty Hardin is hired as his criminal defense attorney. We can talk a little bit about how Rusty Hardin's been handling the case. Certainly we've covered it on our podcast. We want to spend time on the hearing. But the fact that Watson decided to bring in, he's already hired a top criminal defense attorney in Rusty Hardin. But he doesn't want Rusty Hardin by himself handling this hearing. So he brought in the big gun of all big guns, Jeffrey Kessler. Maybe not everybody will have heard of the name Jeffrey Kessler, but look no further than the recent hearing, NCAA versus Alston, the case that really paved the way for name, image, and likeness in college sports. You can name about 30 Jeffrey Kessler cases. He's an attorney at Winston-Strawn, but he's the guy. He's the guy if you want to call someone in. So Watson has brought in the big guns, and he is, I think the plan is to fight this thing as far as it needs to go. Potentially an appeal afterwards if they don't get the
Dan, just one little clarification on Jeffrey Kessler. He's retained by the National Football League Players Association. So under Article 46, the player can have his own counsel, and the Players Association is a party to the proceedings. So
we'll say the PA brought in the big guns for Watson.
I'm not. Well, Jeffrey Kessler is the counsel of record on all of these cases. We saw him in Ezekiel Elliott, Deflategate. I mean, he really has the monopoly. For good reason. He's one of the preeminent sports antitrust and sports trial attorneys in the nation, and he's done such great work for the DC, for the PA. But I'm getting a lot of questions on my timeline about some of the legal maneuverings that could occur after the judge's ruling. So what I want to clarify here is that under the new Article 46 of the CBA, it's a different kind of review process. Remember, under the older CBA, Roger Goodell and/or his disciplinarian, it could be anyone league associated, would determine the initial discipline, and then you appeal it to Roger Goodell, who would probably rubber stamp that same decision. That's all changed in the new CBA. So this is why Sue Robinson has now been jointly selected as the hearing officer. She's a longtime federal court judge. So what more for you, Cleveland asked me, who's been very polite and kind of publicizing our legal insights, is what happens next? What if Judge Robinson imposes a suspension of a determinate number of games, let's say 6 games, 8 games, and the NFL doesn't like it? Well, what's next? The NFL would take an appeal they would be required to file an appeal within 3 days of the disciplinary officer's ruling. And guess who the appeal is heard by?
It's wait, call me Dan.
Come on, it's yes, go ahead. We do this every time. It has to be a rhetorical question. It's Roger Goodell or his designee. So
that's what I was going to say, Dan. But go ahead.
We have the prospect here. We have the prospect here where the NFL, unhappy with the length of the suspension, is going to have its own commissioner determine how to handle the appeal. Now, on the appeal, Goodell can't overturn any of the findings of the disciplinary officer, but he can alter the suspension, meaning he could reduce it, which isn't going to happen, or he could lengthen it. So let's say Sue Robinson imposes a 6-game suspension, and then you could have a situation where Roger Goodell, as the appellate judge, says, I'm going to make it 1 year and then keep it open indefinitely, which is the original discipline that the league asked for. So it really raises a very intriguing, issue that could come up as early as next week as to how respectful the NFL will be of the disciplinary officer's ruling.
So certainly continue to send your questions in. I'm going to answer one that we got in, and Dan, you kind of left us to a good point. So someone asked, and you and I have got this question on radio this whole week, is Watson better off with this new system under the 2020 NFL CBA, which, Dan, you and I covered on the podcast once upon a time? They snuck that just under the wire right before COVID hit. So that CBA has been in effect since 2020. But for better or for worse, Sue Robinson is not really that battle-tested with the delays with COVID and whatnot. Just there haven't really been a chance for us to see what she's going to be like. So, Dan, you did some research into her, which I will, I'll give you the floor for. But the question is this, right? Dan, you bring up this point that at the end of the day, right, under the old system, Roger Goodell was the judge, jury, and executioner. Now we have an interim step that's going to be Judge Robinson. But then it still does go to Goodell at the end of the day. There is certainly a world, and we can't rule it out, right? That's how the system allows it, that Goodell gets the final say. And he can lengthen the suspension, he can shorten the suspension, or, right, just call a spade a spade. He can reinstitute the exact suspension that the NFL has been trying to do before this hearing started, which is a year minimum plus an indefinite term thereafter. So the question is, what would prompt Roger Goodell to, be the good guy here and go for some type of suspension length that isn't what the NFL, right? Goodell is the NFL, what he hasn't already wanted. So we can say whether this is a good system or a bad system for Watson, but it's all speculation. There is a world where, let's say Watson wins this appeal, right, and Judge Robinson sides with Watson. It goes up to Goodell, and he goes, you know what? Nah, I'm going to go with exactly what we recommended on the first time that Watson should get.
Well, Dan, he can't do that. If she finds that discipline isn't warranted, that's finality. He's only able to modify the punishment. To clarify, if they say, if Judge Robinson says there should be a 6-game suspension or an 8-game suspension, that there is a finding of some type of misconduct, right, and he can lengthen it, or I would think, Dan, in all likelihood, return to the initial, recommendation that he had here. Well, then what that would set up is round 3 of this heavyweight boxing battle, which is a federal court lawsuit. Those of you who've been following the history of player NFL disciplinary disputes recognize that so many of these end up in federal court, but they end up in federal court only after there's a final administrative determination within the league. So if Roger Goodell exercised his discretion as the appellate judge to lengthen the suspension, I think the Players Association would file a lawsuit in the United States District Court, maybe even in Delaware, where this arbitration or disciplinary proceeding is taking place, and have a Delaware federal court judge vacate the final arbitration appellate ruling by Roger Goodell. So there's so many possible legal points of entry here. We've got to keep our eye on this proceeding. Then there's the appeal to Goodell, and then if Deshaun Watson is not happy with the outcome following Roger Goodell's appellate ruling, then it could end up in federal court in either New York, Delaware, or who knows, maybe even in Cleveland or another market. So all of this is going to take place during the course of the summer. There will be a final decision, at least at the lower court level, in round 3 before the beginning of the NFL regular season. If you remember the Ezekiel Elliott and the Deflategate cases, those were federal court lawsuits that ramped up in early August with rulings on an emergency basis. They were filed as original proceedings in federal district court. They were not appeals. It was judicial review of a labor arbitration ruling, which is like an appellate proceeding in that there's a very limited record and you can't take new discovery. But one of the reasons I think that this disciplinary proceeding is taking place in June rather than during the NFL regular season or even later in the summer is to allow for the possibility of subsequent proceedings before Roger Goodell and potentially a federal court judge, with all of that, kind of coming to finality, at least on the district court level, before the beginning of the NFL's regular season. And I think Judge Robinson is going to be a very pivotal figure here because as a longtime federal court judge, she's likely going to give consideration to some of Deshaun Watson's arguments about disparate discipline. I mean, she was a federal judge who handled employment discrimination cases, and disparate discipline is a cause of action that can be raised in the Title VII context. And she has a little bit of a history in adjudicating disputes like that. So I think his main defense around the selective enforcement of this policy vis-a-vis the owners relative to Watson, I think that has the chance of resonating with her. And equally important, I think she's likely to be dealing a pretty fair hand to Deshaun Watson on discovery issues and requests for access to evidence. And he may find a very willing judge on the issue of further inquiries around some of these defenses he's going to raise. Now, if Goodell had been the hearing officer, he's going to shut that down, and he did that at Deflategate. And Harold Henderson did something very similar in the Zeke case. So I think it's helpful that Deshaun Watson is proceeding here before a long-tenured federal judge with a great reputation.
Okay, so as I'm scrolling through the chat, I see a lot of browns, orange, and brown. So we should kind of address, right, the potential for a suspension after the suspension. Dan, that's a point that you and I have talked about on the podcast. Why the NFL, in theory, is looking for a year suspension and then an indefinite length thereafter, and the reports are that they would allow Watson the ability to apply for reinstatement, is this issue just in terms of timing. And I'll try to be as explain as simple as I can on the timing. According to the trial scheduling order, that's with these 4 pending cases. The trial in those cases cannot be held until after next year's Super Bowl. So that's in February of 2023. The trial would probably be March or April, right around there. And we also still have the potential for more cases to be filed. We were talking earlier that there was a report from Tony Buzbee that a 25th and 26th case were supposed to be filed. They haven't been filed yet. In that same, within 24-hour period, Buzbee said that he was going to bring the Texans into the lawsuit, which he did earlier this week. So I don't know, he's followed through on that. So there are certainly other cases that could be filed here. So Dan, there was a world, and there still is, if there is a 1-year suspension that's levied, and it's not this indefinite length, right? And whatever the result of this hearing, be it Goodell's decision, be it the judge's decision, or via some type of agreed upon settlement of 1 year, there is still the possibility, right, until we hear how this hearing works out, where the NFL finds out something new afterwards, maybe a year down the road, maybe another individual brings a claim with some cases that we didn't know about. So that's why the NFL is trying to have this indefinite length, so they can just kind of have a catch-all thereafter. Dan, do you think there's anything kind of, and I know the answer to this, but sometimes we deal in rhetoricals, do you think there's anything that prevents the NFL from having this indefinite suspension? Certainly it seems unfair, but my sense, which I'll key up a little bit, there seems to be some authority for them to do this.
No, I think past precedent is not going to matter here. If I'm Judge Robinson, I tell the NFL, well, if and when there's a future, incident that comes to light, then we'll deal with it. But you can't have this open-ended, vacuum here on the mere possibility that there are going to be additional cases coming down the pike. I mean, the NFL has chosen here only to proceed with, 5 out of the 25 plaintiffs, and they're focusing on 5 claims. And I think it would be patently unfair and fundamentally unfair to have this, sort of open-ended, time period in which, Deshaun Watson's status remains unclear. If the NFL really truly felt this way, they would have placed him on the exempt list, on the commissioner's exempt list a year ago. So that they can investigate these items. You can't just keep them, in hyperspace in perpetuity, and the time to deal with it is if and when there are additional alleged personal conduct offenses, and then maybe they become a multiplier where he can get additional discipline, but not now, not on mere speculation.
So the only issue, and I see we've some people in the crowd clapping in that response. So Dan, if we were doing a live crowd, there'd be a clapping right now in person, which would be cool.
Yeah, I know how to play to Cleveland, I guess. I don't know. I'm not doing this on purpose.
No, but I'll push back a little bit, right? We are lawyers. We are trained in the art of negotiation over here, and just going back and forth. Dan, the truth is, right, Calvin Ridley, our last one-year suspension in the NFL, I mean, we could call it an indefinite suspension, but it's just semantics. Calvin Ridley is suspended for a year, and then he has the ability to apply for reinstatement thereafter. So in theory, it's not that different than what they're looking at Deshaun Watson, but there's been a lot made about this indefinite time length. The only thing that's different between Ridley and Watson, obviously there's a lot of things different, but in terms of what could happen thereafter, we do expect some additional news to come out with Watson after this 1 year of time, just because of the way the trials are set up and the statute of limitations haven't run in this case. Whereas Ridley, I don't think anybody expects him to be a recidivist, to do the thing again. So that's why people are saying that this indefinite time length kind of might actually come into play with Watson, where it's unlikely with Ridley when he reapplies for reinstatement.
Well, and here's why, Dan, I think the two situations are markedly different. Ridley was suspended for violating the league's gambling policy. The personal conduct policy is a different policy, and that's the one that Deshaun Watson is governed by. And I don't see anything in the personal conduct policy that gives the NFL the ability to, correct me if I'm wrong here, but isn't there like a baseline, 6-game minimum suspension for first offense, and then second offense will result in permanent banishment from the NFL, and then you can petition for reinstatement after 1 year. So I suppose there's a range of punishments that are prescribed in the personal conduct policy. There's no suggestion anywhere that it can be indefinite. And if the disciplinary officer opts against an indefinite suspension and then Roger Goodell decides to impose it, basically overriding Judge Robinson's determination, I think the NFL is going to set itself up for a federal court smackdown of not following its own rules. Because if they're basing a suspension on something that's not even in the rules, then they're not even applying their own rules, and that's going to be one of those narrow bases under which you can vacate a labor arbitration award. The track record in getting labor arbitration awards overturned in federal court is like 1 in 100. I mean, Tom Brady is Elliott.
That's Mr. Brady.
Yeah, they all lost, even though Brady, Elliott, and Peterson had very strong cases on procedural unfairness, the denial of access to evidence. And with Adrian Peterson, the league was attempting to discipline him under a new policy for conduct that predated the policy. So they had, despite what people think about the underlying offenses, they had very strong grounds for overturning their punishments. So if Goodell decides to go the indefinite route, which is something that's not even contained within the personal conduct policy, I think he basically opens himself and the league up to having this be one of those rare cases where a federal court would overturn the suspension. So I think Judge Robinson will want to protect the record here and not opt for such a punishment that appears nowhere among any of the rules, guidelines, or range of punishments allowable.
Right. So just to further that point, and we wanted to do a little bit today. We'll see how this goes, but we wanted to try to give a sense. Obviously these hearings are confidential. Some things are leaking. As we had Josina on, she seems to be a good source. So if you joined us late, certainly follow Josina Anderson. And again, we're going to have the audio of this spaces up on our podcast feed, Conduct Detrimental. Definitely give us a follow and subscribe, like, review, all that fun stuff. So Dan, you mentioned a really big point here, and obviously, when we're talking about precedent. What lawyers do is we look back in the past, we try to find a case that's pretty similar, and we use those similar cases to predict future outcomes. So you ask me, I think the case that's maybe closest to this, and it's hard to find a case that where 20 plus accusers are accusing someone of doing something, right? But the one that's most recent that was done under Roger Goodell's watch was the Ben Roethlisberger case that involved someone that was accused on two separate instances of, we'll say, different types of sexual misconduct. Roethlisberger received a suspension, I believe, Dan, don't quote me, I think it was 10 games, it might have been 8, but it was reduced. It was cut down to a lesser number than that. There just hasn't been a case like that. So, Dan, we're looking at 20 plus civil lawsuits. Again, my understanding is that 5 women are going to be brought up over the course of this disciplinary hearing. So it's not all 24 that filed suits are going to be a part of this, but they've isolated 5 in particular. Dan, I think people got lazy early on when these cases first dropped. Like, hey, let's take Roethlisberger and let's multiply it out by 20, and Watson will never play in the league again. There is no one saying that anymore. I think that was just those.
Oh, actually, there are, but we should pay no mind to them.
They're the people in your replies yelling at you.
No. There are some people who think that, listen, technically, theoretically, each subsequent offense, the second victim, third victim, fourth victim, I mean, theoretically is like a repeat violation, and repeat violations will allow for an escalation of the punishment under the personal conduct policy. I mean, that happened, that came up briefly in the Ezekiel Elliott case from 2017, in that, if there is a second offense, it would result in permanent banishment from the National Football League. That's right in the personal conduct policy. So with Elliott, there was, I guess, an alleged incident involving some other person previous to the draft when he was at Ohio State, and that didn't come up in the hearing, but I remember the risk factor associated with that because the danger of having even a 6-game suspension, it's your first strike. So the first offense is your first strike, 6 games. So there's the possibility, at least theoretically, if you strictly interpret the language in this personal conduct policy, that each subsequent offense could lead to a permanent banishment, not just multiplying 26 victims by 6 games and landing at 130 some odd games. Just the second offense could result in permanent banishment from the NFL. So that's what he's dealing with, and that's the possibility, the doomsday scenario of Roger Goodell not liking Judge Robinson's ruling and deciding to not only extend it in perpetuity, but up through and including a potential permanent banishment. He has that right under the way the collective bargaining agreement is currently written. He can alter the suspension, modify it, decrease it, increase it, but there's no cap that limits him on how far he can increase the punishment. So that remains a theoretical possibility, but it's going to lead to a holy war with the NFLPA and a major court battle. So I think it bears watching, but I don't think he's going to do it, but he could conceivably do it.
Yeah, I don't see it happening, but again, we just got to float out the alternatives here. So again, on a related note, right? Let's talk about the Cleveland Browns here, who are watching this very closely. The Houston Texans are watching it closely as well. We dedicated a whole episode to the Houston Texans stuff. So let's talk about the Browns for now. Again, the Browns commit the biggest guarantee in NFL history, $230 million, and includes a $45 million signing bonus that's already been paid. He's under contract this year, assuming he does play, for $1 million. Now, Dan, we've gone back and forth about this. I am under the impression, right, if you just want to believe the Browns press conference, all the news that came out of the Browns, that they did their due diligence, right, that they looked into this and, they knew everything, right? At least from my vantage point, if the Browns knew everything that we know, right, Dan, what you just said, that there's a potential, right, within Roger Goodell's purview, he could assess 24 different types of punishments, right? The fact that 2 new lawsuits came out, the fact that the Texans might have been involved, Dan, and the fact that maybe the NFL was looking at an indefinite suspension. If the Browns knew all of this and still opted to commit $230 million guaranteed, I don't know what that says about the Browns, but they have more risk tolerance than any team in NFL history. It's never happened before. A contract of this length, just in terms of contract length and guarantee, has never been given to a Josh Allen, a Patrick Mahomes, and Aaron Rodgers. So let alone all the different red flags that we're talking about.
Okay.
I don't know where.
Dan,
let me just. I'll give it to you with this. Dan, do you think there's a world where the Browns try to get out from under this contract as a result of what's going on here? Let's say it's the worst case scenario at the hearing. You think the Browns try to get out of the deal?
Zero, because they were already on notice of the existence of 24, 25 lawsuits. They could have done due diligence. None of this came to the Browns as a surprise. If they were aware of 24 cases, really they were on inquiry notice to do their homework as to the possibility of subsequent plaintiffs. But the bottom line is the signing bonus. The signing bonus can't be clawed back. I've made this point on CBS in Cleveland. Under the CBA, you can only claw back the signing bonus if the player holds out or is incarcerated due to his own, it was the Plaxico Burress clause. So with the Cleveland Browns already on the hook for the signing bonus, I don't think they're going to be able to get out of this contract. Very limited. And teams have tried this before. I think that ship has sailed. Did they overpay in retrospect? Of course. But 3 years from now, they're going to have one of the top quarterbacks in the league, and I think it's a question of maybe they overpaid in a distress situation, not that they were blindsided by the fact that Deshaun Watson is being accused of sexual misconduct when there were already 24 cases pending. That case is not going to go anywhere. Of course, with Roger Goodell as an arbitrator, this is the wild card here, because if the team tries to void the contract, this won't be heard by a judge in state court or federal court. It would go to Roger Goodell as the appointed arbitrator under language in the standard player contract. So the prospect is not whether I think it's a good legal argument, but the hometown home cooking that Roger Goodell may extend to the Cleveland Browns. But I don't think they're going to do that. It just doesn't make any sense. They were already on notice, and just the existence of a few more cases isn't going to change that calculus or really result in such an unfair surprise. And it goes to the essence of the entire contract when they were already buyer beware and of notice of all these potential problems.
There's as we do on our show, Dan, we try to explain to our sports fans some legal terms here. There's one that law students, lawyers know well. There's this understanding of this common nucleus of fact, right? If there is a 25th, 26th, let's say a 30th lawsuit, Pro Football Talk had a report this week, there could be up to 30 lawsuits filed in this case. Either way, right, what are Watson's team going to argue? And let's say the Browns, they take the unlikely event. They've already parted with 3 first-round picks. They've already dished out $45 million. Let's say that, we want to get back the additional 180 that is going to Watson, my rough math, right? Watson's camp will say, listen, you guys had an opportunity to do your due diligence. You had an opportunity to speak to everyone involved. And unless there's really a case that falls out of the temporal element between 2020 and 2021, right, all of these cases involve masseuses. Unless something involved something outside of that time range and, right, some event that didn't involve a masseuse, I think Watson's camp's going to have the argument here that they cannot get out of that deal. So, let alone the fact, Dan, to your point, I don't think they would, because they've already paid out the money and given up the draft picks.
I'll tell you, I got tons of questions in my timeline. Thank you, everybody. Thank you, Ian. Brown Chubby Bear, days until NFL kickoff.
Wait, what was that? What was that? You said Brown Chubby Bear?
Brown Chubby Bear. Yeah.
Is that appropriate to say? Brown Chubby
We get all types. So this is a question from Leo. We wondered if it was. Let's start taking a few questions we've had. Our audience has been so patient, sticking with us for almost an hour. So the question is it bad? Dan, I'll pose it to you, and maybe I'll try to follow up. Is it bad precedent for the NFL to suspend players for settling cases in civil suits with allegations that said player denies? Is this a slippery slope that could end up causing any and every player who gets falsely accused and chooses to settle to avoid bad public relations a suspension? Imagine if Tom Brady's accused of something, he settles, and now he gets suspended for it. I think I've always made that point that using unsworn civil allegations that have never been adjudicated as the basis for either discipline or paid leave, you're weaponizing plaintiffs' lawyers and potentially incentivizing victims to run to the courthouse and knowing that they're going to hold leverage over the player, because if they file a lawsuit, maybe the player will quickly settle to avoid a possible NFL suspension and the end to his financial benefits. So it places players in a really unfair position relative to their adversaries in a civil court proceeding. So Dan, do you think it's something that the league should steer clear of and wait for an adjudication, or does each case involve its own sort of fact-sensitive inquiry?
2 points or examples, right? It doesn't always happen, right? Sometimes a player is accused of something very messy, and there's all this talk about a suspension, and they don't miss a game, right? I'm remembering this past season, Dalvin Cook was accused of a domestic incident that involved some element of violence. He denied it, and he was not suspended. I was ready on the waiver wire to pick up the Vikings backup, whose name escapes me at this point, but he didn't have any type of suspension and denied it. So Dan, that's point one. It doesn't always happen, right? So we could say it's going to set a bad precedent, but when the NFL is not always doing it, it's tough to say that there's a precedent that's been set. Dan, the other side of this, I think the real interesting one, and as we, my mind goes a lot to the Snyder congressional hearing stuff, and I know you don't want me talking about it, but I will say, Dan, the Dan Snyder case, what did it involve? Sexual assault, sexual harassment, someone paying someone $1.6 million to settle a claim, which I'm sure Snyder denies, but he still paid $1.6 million. It sets a bad precedent. If Watson gets punished for settling claims while still saying that he's innocent, right? Watson has never said he did these acts and he's always denied it, but he paid, right? Sometimes, in life, I hate to break it to our non-lawyers in the crowd, sometimes you settle a case just for economic reasons, right? Just because you don't want this case hanging out. Sometimes it costs more to defend than the case is actually worth. So I don't know what Watson's reasoning were settling the cases this time around when he didn't settle a similar deal that occurred, when he was reported to be traded to the Dolphins. But Dan, it sets a really bad precedent. If Dan Snyder gets zero, an actual suspension, actual banishment from the team, and Watson, who, I don't know, he's denying it, but he settled it, he'll end up with a year in this indefinite suspension. So I think it's a very slippery slope, especially when owners have really never been punished. So that's the precedent I'm concerned about. If owners are really going to be held to the same standard as players, at some point an owner is going to have to be punished for the same exact conduct that players are about to get banished for an indefinite length for. I think it's only fair.
We got a great question from Guiding Light at Tech, or CA Carp 75, 51 years young and living one day at a time by the grace of God. Definitely. I like that. His great question is, he was wondering if the Texans as a team face any penalty if they didn't tell the Browns and the NFL about the NDAs. Could the Browns get some compensation for not being informed of all the facts, i.e. the NDAs? Great question. Go ahead, Dan.
I think it's a better question than Brown Chubby Bears question. Not as good of a name, but I think it's a better question. Dan, we've talked about it. For those that don't know, just brief history. The NDAs were allegedly provided by the head of Brown Security, a former Secret Service member, after one of these alleged masseuses, took to Instagram and threatened to out Deshaun Watson. So the Texans found out about it somehow. It's not really clear if Watson told them or they saw it on social media. And instead of, the allegation, this is a New York Times reporting here, we'll give Jenny Brent this credit. The allegation is that the Texans didn't step in and say, hey, Deshaun, what are you doing? They said, you know what? Essentially, I'm making it up as we go, but essentially, don't not do it. But if you're going to do it, Deshaun, we can't stop you. Just have an NDA so no one takes to Twitter or Instagram without some type of legal ramifications. So that's the crux of the complaint. And that's why, interestingly, Dan, only one plaintiff, one of the remaining plaintiffs sued the Texans. It wasn't all the remaining four. So the question is, Dan, do we think that the Texans could face some discipline? Yeah, I do. I think it's a question of whether the Texans, were honest and forthcoming. If the NFL knew about this, if the Browns knew about it, I think it's very different. But again, I'm sure the Texans are going to deny this. I'm sure they're going to put up a valiant legal defense. But assuming this is true, and assuming, one other level, two levels of assumption here, that the league never knew about this, then I do think they're open to discipline. You can't just expect to get 3 first-round picks from the Browns while hiding information and while facilitating the acts that might result in this suspension. So I do think they would be.
I think personally, the Cleveland Browns have a real grievance here against the Texans. I mean, they're in trade negotiations.
Assuming it's true.
Hold on a second. Hold on. What the Texans didn't tell the Cleveland Browns First of all, Deshaun Watson is denying the allegations. The Browns are making a trade for him based upon, okay, this is all going to eventually go away. But what the Texans didn't tell the Browns is they arranged the rooms, they provided the massage equipment, and they prepared the NDA and gave it, to Deshaun Watson, who presented it to the massage therapist. Did the Texans tell the Browns any of that? Because had they made that disclosure, it might have created some doubt in the minds of the Browns management team that, do we want to trade with this player? Because those facts lend some support to the plaintiff's allegations that something happened here. It undercuts any notion of a denial, and maybe the Browns don't even trade for Deshaun Watson had they known of the collaboration, or at least the activities undertaken by the Houston Texans, that they kept silent from not only the Browns, but from the National Football League. So I think if I was the president or owner of the Cleveland Browns, I would want to, approach the National Football League and say, listen, they didn't tell us about any of this. These are material facts that go to the credibility of the allegations, and they concealed them from us during the trade negotiations. I wouldn't ask for the deal to be unwound, but I would ask for some modifications of the deal in light of the material omission, which in our world amounts to like almost tantamount to fraud. If you have a duty to disclose material facts and you fail to disclose those facts, that's almost or equally as bad as making a false misrepresentation. If you knew that those facts mattered and would have affected the decision-making of the counterparty, especially in the National Football League, given the allegations that were made here, I think it rises to the level of a fraudulent omission.
So, Dan, I'll do one further here. In addition, I agree. I'll second everything you just said. The part that I've always found confusing, and Dan, someone was in your replies yelling at you today, and I always have your back.
It's okay. It's fine. We're all entitled to our opinions, and everybody. Not if the
opinion's wrong. You're not entitled to that. And Dan, Dan stick together unless your last name is Snyder, and then we do not stand with you. Dan, so let's go further on this Texans analogy, right? I did Houston radio today, and I said, just common sense tells you there was some implicit agreement between Watson and the Texans and the NFL, or two of those three parties. You picked your two. To have Watson not play last year. Obviously, he was paid in full, but Watson never filed the grievance, which he was certainly entitled to if he felt he should be given the right to play. Again, my question to you, just on that same level of what the Texans maybe could have done differently. The Texans obviously, we'll say obviously, but assuming these reports are true from the New York Times, the Texans knew more than they let on, and they knew more while Watson was still a member of the Houston Texans organization. So the question is, Dan, that I have for you, if the Texans, right, certainly they weren't incentivized to tell the NFL about these things in real time, because that might have sped up the time frame for potential suspension. And if Watson had been suspended or put on the exempt list while he was a member of the Houston Texans, Dan, I think that would have severely hurt his trade value. So I'm not just concerned about what the Texans knew during the trade negotiations. I'm concerned about what the Texans knew during his entire tenure with the team, because they had all the incentive in the world not to tell the league what they knew, because they ended up getting Dan a king's ransom. So, I think that's got to be looked into as well.
Dan, I think it's conduct detrimental, right? All throughout the CBA, the bylaws,
there's the podcast,
the bylaws, the NFL Constitution. You have conduct which, if the commissioner, and this is very open-ended, but I would think failing to tell the National Football League of the Houston Texans' own involvement in this alleged sexual misconduct, failing to tell the National Football League about this, clearly rises to the level of conduct detrimental to the integrity of or public confidence in the game of professional football. So, listen, look at how frequently Roger Goodell uses that conduct detrimental clause as sort of an omnibus provision to assess discipline against multitudes of different players, coaches, owners. This is about as serious as it gets. If this doesn't create a basis for discipline, then I think the application of the clause is basically arbitrary and capricious. It's whenever it suits Roger Goodell to apply it, but certainly concealing the team's own involvement in alleged sexual assaults against multiple women is grounds not only probably goes beyond that conduct detrimental provision, but
Dan, are you just trying to say the name of the podcast
no, it could,
as much as possible?
Dan, this is so we've done this so many times. I'm trying to make a very serious point here. This is like you bet your life with Groucho Marx. Whenever you say the word, the duck comes down from the ceiling.
That's exactly what
you can't talk about misconduct in the National Football League without using that terminology. It gave rise to our show. So I think from the Houston Texans' vantage point, they're facing two serious legal vulnerabilities. They've defrauded the Cleveland Browns by not coming clean about what they knew during the trade negotiations and, just extracted a king's ransom. And had they made that disclosure, clearly that should have changed the calculus and what the Browns were willing to give up. And then they swept under the rug their own involvement in a sexual misconduct scandal. And if they were to walk away clean here, I mean, that's going to be an issue going forward against the National Football League. Anytime a player is accused of sexual misconduct, if a league doesn't discipline the Houston Texans organizationally for what they failed to disclose to the league of such a serious magnitude, it's going to create problems for the league every time it tries to discipline a player for any kind of personal misconduct policy violation, because it's going to open the league up to selective enforcement, disparate discipline every time. So Dan Snyder, Jerry Jones, Robert Kraft, and now the Houston Texans. The league is creating a perpetual problem for its ability to impose discipline by not disciplining league officials, teams, owners, for conduct that in some situations is far more grievous than what the player may be accused of.
Dan, if you say conduct detrimental 4 times, I'm going to have to acknowledge it. It's the name of the podcast. Yeah, that's assumption of the risk at its finest. Dan, let's go back to a point that you raised with Josina, and I don't know how much I don't have that much more, Dan, but I did want to address this point with you. It's a comment that it's an ill-advised comment by Rusty Hardin, Deshaun Watson's attorney. But on radio, I think it was Houston radio of all places, a couple weeks back, Rusty Hardin, was giving an analogy, or I don't even know if he was giving an analogy or he was just actually stating his defenses. But he said, reminder, right, getting a happy ending at the end of massage is not necessarily illegal. So ill-advised because a lawyer should not be saying that, shouldn't be saying it on live air, but also ill-advised, right, because those are some facts, as they say as lawyers, facts not in evidence. We've never heard about that. So why I want to bring it up in this context, right? Robert Kraft was alleged to have been involved in, and we'll say something similar involving a massage conduct. We talked about Dan Snyder, Dan, who didn't receive any type of, formal suspension, I believe, for the sexual assault and harassment conduct. At least there's no written report confirming exactly what he was suspended for. Robert Kraft didn't receive any type of suspension for that. And obviously, there's no allegations, I believe, with Robert Kraft of an issue of consent with these type of massage conduct. We have that, this non-consensual issue with Watson. But Dan, is it possible that this is the closest precedent we have on point that the NFL has ever had to deal with, right? I mean, we could talk about player precedent, but what Zeke did or what Brady did or even what Roethlisberger did, it's not really, on all fours what we're looking at with Watson, right? Isn't massage conduct, isn't the only precedent on books what happened with Robert Kraft? I mean, and that resulted in no suspension to speak of.
That's right, and he was charged criminally, and he would have gone to trial in a criminal case had the appellate court not stricken the evidence as violating the customer's privacy rights. But there's also Jerry Jones. Jerry Jones was sued in a Texas state court in 2014 by an exotic dancer who accused him of forcibly touching, her private areas, and he allegedly paid her for 4 years to keep quiet about it. So
how many games was he suspended for?
0, right? So, you have the issue of one incident versus 24, 25, but it's still one incident that the NFL decided to sweep under the rug and never conduct an investigation on, much less discipline him for. So you have you have an exotic dancer with the Dallas Cowboys owner and a massage, parlor with the New England Patriots owner. So you're kind of orbiting around sort of the same alleged misconduct, maybe less frequency, but certainly you can point to it as a valid comparator. And Roger Goodell in 2019 said the personal conduct policy applies to all of us. So I think it's a valid comparator for purposes of disparate discipline. I want to call up a few people, Dan. I think people might be tired of. I know we haven't lost the audience yet.
Do you want me to do it?
Can I call one in?
Well, you got to do one of the 4 that are up there.
Yeah, angry Browns fans.
Okay.
There are a lot of angry Browns fans today. Let me
Listen,
check the box on him.
We're going to trust you here, angry Browns fan. You got to.
I vetted him. He's okay.
Okay, you're up. You're up, angry Browns fan. Steven, you're on deck. I see you in your Browns gear.
Did I do this right?
Angry. No, we got him. He's good. He just got to unmute. I'm a little nervous about angry Browns fan. I feel like he's gonna drop a promo on us. Angry Browns fan, you got to unmute your mic. This is like sports radio when the caller calls up and he's
good call.
Feedback on.
Good call. Sorry, can you hear me?
Oh, good.
Yeah, perfectly.
But we've been promised an angry Browns fan, so you got to deliver.
You sound jovial, actually.
Pretty laid back dude. The name was Irony, and stuck with it. Whatever. A question for Dan. I just heard his lecture.
Question for Dan
Wallach. Sorry.
Okay.
Oh, Wallach. Yeah, go ahead.
What you just said about the Texans not providing as much information or being as forthcoming about Watson, that they knew more than what they let on, which I'm sure they did. Does that really matter from like a legal standpoint or a sports legal standpoint? Like if you're trying to trade someone, you're not going to, unsell who you're trying to get rid of. Does that make sense?
No. Yeah, but they knew that the allegations were true because they were involved in it.
I mean, he had 26 or 20, however many cases that didn't go to indictment or whatever the hell the legal terminology is. Like the whole country knew shit was going on, whether or not they.
But they didn't know. But they didn't know that the Texans had any level of involvement and, supplied the NDA. They prepared the NDA. They knew about it.
Oh.
They knew about it. So, listen, would you think that there would be angry Browns GM if he found out, that the Texans kept this information from him? Would it have affected, if you were the general manager of the Browns and were thinking about making the trade, would having this mix of information available have swayed your decision-making process as to the cost?
For sure, yeah.
I'd be willing to.
The Browns should be pissed, but it's also like I'm not going to exonerate them from what I think was a stupid decision just because it's like he knew something was happening. He knew the NFL was going to bring the hammer on him. At least they should have. But
that's the reality. That's the political reality or the practical reality, and you're probably right.
Yeah, I mean, it's the Me Too era, and no case that I know of has ever gotten this much publicity. But I guess from a moral standpoint, yeah, I think that not being forthcoming is wrong, but do they really care? Or like, is there any type of precedent you can't withhold medical information in making a trade, if I'm not mistaken?
It's happened in baseball before. If you're
what about
this? Just really quick. I mean, I think the most recent trade to get walked back in sports history was a medical information withdrawal. That's I think it was AJ Preller with the Padres. I think and the Marlins were involved back in the day. So it's happened, right? There is precedent in sports. I don't recall it happening in football, but yeah, you can't hold that back. But to Dan Wallach's point, right? We're not talking about. Dan Wallach. Actually, it's just Dan. You can actually just collectively refer to us as Dan. We'll respond. Yeah. But Dan, go ahead, Dan. And
here's where the Browns fucked up. If you might excuse my French.
Mr. Angry Beaver, I'm going to put you back in, but you appreciate it.
Yeah, no. Let me. This is where the Browns screwed up. They should have insisted on a representation and warranty. Most lawyers who negotiate contracts, insist on reps and warranties that the Browns or the Texans aren't aware of any additional information regarding, the veracity of these allegations. You can insist that the Texans put their cards on the table to the best of their knowledge, that they're not aware of anything else that's going to come out that they're keeping hidden from the Cleveland Browns. So maybe it's negotiating negligence by the Browns, but I also believe that the Texans played a little loose with the truth here, and that could be a basis for seeking compensation. Just like when you sell a house to somebody and you don't tell the buyer of the house of some latent defects that are hidden within the house. I mean, that's like grounds for rescission. I'm not saying the contract is going to be rescinded or the trade is going to be rescinded, but I think the Browns have a pretty decent legal leg to stand on, but for the fact that Roger Goodell obviously has an interest in, kind of maintaining the peace here.
I'm gonna say one thing, and then Stephen, I see you. I'm calling you up next, I promise. Just to close the loop on this, and then Stephen, I'll call you up. AJ, I see you. Stephen's been here since day one. I think since like minute one of this. The one thing that we should hit, and we're trying to just give you guys all the knowledge in our head about this case. We did mention back in last year's trade deadline, there was a reported deal to the Dolphins. The Dolphins asked reportedly Watson to settle all of his cases, and the lawyers did their best. They could only settle 18 of 22. And Watson, again, all rumor and innuendo, I'm just reporting what's been out there, said essentially all or nothing, then I'm not settling the 18 if I can't get all 22 settled. The question is, why didn't he take that deal then, but he basically took that same exact deal a week ago, right? Because we have 4 cases remaining, 18 of 22 is 4, 20 of 22 is 4. The question is, right, what was the motivation to do that this time around? And I think, Dan, I am tying these together, I promise, the Houston Texans element. Because if all of these cases settle, right, there's no lawsuit in theory to bring against the Texans, right? This is a case that really requires Watson to be involved. So I think if these cases did resolve all of them, all 24, I think that would be a way to try to protect the Texans in some way, shape, or form. But now that these 4 cases remain, one of those plaintiffs, not all 4, to be clear, only one of those plaintiffs has sued the Texans separately, and that's under theories of vicarious liability, civil conspiracy, and just a pure negligence theory. So we'll obviously keep our tabs on that, but that was the big news this week. Yeah. Okay, Stephen, I'm ready to call you up, buddy. Okay, AJ, you're on deck, and Dan, I'll let you get the call for the next one. This was okay. We're almost like picking a jury here. You got to pick, I got to pick, then AJ's a return guest of the show, so he's like the communal pick. Stephen, you got to unmute your mic, and then we're good to go.
Hey, good afternoon. Here. I have like a little bit of a 2-part question, so just it kind of goes like with the CBA, none of the agreement, there is maybe it's a paraphrase, but it goes that the owners are to be held to a higher standard than the players. With that being said, with everything going on that you guys spoke about earlier, what we know about Dan Snyder and etc., would that give Deshaun Watson grounds for a good appeal if it goes wrong? And part B, with your professional experience between both of you, how do you see this really playing out as far as the suspension? And thank you once again for getting me up here and taking my questions.
Thank you. Great question. I'd like to answer the first part. I think the question of owners being held to a higher standard, I think the best audience for that is going to be Judge Robinson, because Roger Goodell, when it gets to an appeal, he only has the ability to lower the punishment, increase the punishment. The issue over the selective enforcement of the disparate discipline is not a question that he can take on if there's a further appeal. And I think it's one that a federal court judge, if this got to a later lawsuit, would not disturb any of the findings below just on that basis, because it's a discretionary decision as to whether the judge, is weighing the credibility and making an assessment of the evidence and makes her determination. Either she's going to impose a lesser punishment because it's consistent with what the league has done elsewhere. So I think the whole ballgame on the issue of disparate discipline is what's taking place right now. And if she doesn't take that into account or give credit to that defense, I don't think it's going to resurface later on, either before Goodell or the federal court judge. And I think even if you don't hold them to the higher standard, you at least hold everybody in the league to the same standard. You don't have to say the owners are kept at or held to an exalted standard of conduct. It's enough that they're held to the same standard of conduct, yet the league has treated the players and the owners disparately here for similar types of misconduct. Now, I'm not trying to equate one alleged violation with 24, but the league didn't even undertake an investigation with even the singular, the first instance of alleged sexual misconduct with Kraft or Jones. And I think that's really troubling. And I think that's Deshaun Watson and the National Football League Players Association's strongest argument here, because I think the standard of proof that the league needs to prove to get discipline imposed is only credible evidence. That's a low bar. I think ultimately the key issue in this case is the amount of the discipline that Judge Robinson will impose and whether she gives any consideration to how the league punishes others. And if she does, then you're likely looking at a lower baseline suspension of maybe 6 to 8 games, 6 to 10 games. But if she disregards it, then she's much more likely to impose a more severe punishment of potentially 1 year, if not longer. So her determination as to the number of games will tell you everything you need to know regarding how she viewed these other examples. If she gives credence to them and feels that it's unfair to punish Deshaun Watson much more severely, then he'll get a single-digit game suspension. If she disregards it, then it's the full boat, the whole season.
So I'll answer the second part of the question. So, this is why they say, Dan, 2 Dans are better than 1. You can get the first part, I'll get the second part. I guess a couple things, right? I did mention it. Judge Robinson has a 2-year term. And if you just go back in the history of NFL grievance protocols, or even Major League Baseball grievance protocols, if there is someone that decides against the league, that person is usually not used again. I don't want to say usually, but it's just rare that in these grievance settings that there's a finding for the player. It's usually very, very league friendly. Just the way the history works out. You check the betting odds, if there are hypothetical betting odds on this. The league usually wins at these things. Now, when it comes to Robinson, yes, she has a 2-year term, but that 2-year term is, I think, expired because the CBA was ratified in either February or March of 2020, which we would have just passed it. So, I think if you're just placing bets, it would be an absolute, listen, I'm happy to say it, it would be a shock if Robinson comes back and says that there is nothing here, there was no finding of any type of misconduct. Now, that said, before I get aggregated here, a lot of people were saying the same thing before we entered the grand jury proceedings, and 2 separate grand juries came back, which is a lower standard, right? This probable cause standard is lower than civil court. It's lower than criminal court, yet grand jury returned, with no indictments. So it would be a surprise, but Watson had a really big win before that a lot of people didn't necessarily see coming. So you can't rule it out, but I think the odds tell you in these particular settings, not at grand juries, in sports grievance settings, usually the league wins. So the question was about a prediction. So let's not forget the elephant in the room that's waiting for this. No matter what Judge Robinson decides, as we've kind of laid out here, at the end of the day, right at the end of the hallway, Goodell is waiting there. So you might get one little, you might win the battle, but the war is still Goodell at the end of the hallway. And remember, the NFL wanted a year, and then if you followed the reporting, it looked like then they increased their ask to 1 year plus this indefinite leave. But I think the league really wants a year. So if Goodell, if he has to say, I don't know why he would stray from that year. So unfortunately, I mean, that's my prediction here. I think the NFL went with the year, and Goodell's waiting at the end of the hallway to reinstitute the year. So, I think that's certainly got to be the favorite in the clubhouse.
See, now, I don't think Judge Robinson is going to care one whit about whether she's appointed. And, she's retired. She's been a federal judge for over 25 years, and this isn't her only job, being the disciplinary officer. In fact, in the 1+ maybe it's 2 years she's been the disciplinary officer. This is her first case. It's not a salaried position. She gets paid by the hearing. She's a partner in a major law firm in Wilmington, Delaware. I think she's going to be quite okay if the NFL or the NFLPA decide to pull the plug on her joint selection. So I don't believe this is going to be an example of an arbitrator kowtowing to the NFL in the hope of not losing the cash cow of being paid for these random arbitrations that occur, once every, year, once every 2 years. There's just not enough skin in the game for her to make a decision that's at odds with what she truly believes. Because, she's 70 years old, thereabout. She's a partner in a major firm in Delaware. You're not going to be getting the big-time NFL litigations like Skadden Arps and Paul Weiss get. So this is a limited role, and whether she's rehired or not isn't going to sway her decision one iota. She's going to call it fair and square, just as she did when she was a federal judge appointed for life.
Okay, so
I really appreciate your insight, Dan. And just want to say one thing: with or without Deshaun Watson this year, it has been and always will be. Let's go Browns.
That's right. You win the offseason with all the drama for sure.
So, Dan, while I'm bringing up AJ, I have a quiz for you. You ready for this?
Yeah.
Okay, we said Judge Robinson is from Delaware. Name me a famous football player that attended the University of Delaware.
I don't know. Oh, yeah, of course, Joe Flacco.
You just Googled that, Dan. You Googled that, you snake. I know what you think. I heard you typing.
I can't even type.
So
I'm not gonna be able to Google that quickly. Everybody knows that Delaware is the home.
You
also
didn't know it. You had to Google it, you snake.
Yeah. You know who else is from Delaware? One of our prior guests, Joe Asher.
Oh, I thought you were going to say Joe Biden. I thought that's
Joe Biden as well, Joe Asher. So let's call up the the great AJ Perez. I'm not going to exercise one of my peremptory challenges for cause to exclude AJ. So I'll allow him on the jury. Go ahead, AJ.
No, I asked this similar question yesterday to one of the Dans. This is, how do you see this?
We are actually just Dan in general. We're like Cher, just Dan.
Since one of the Dans actually picked up something during the Zeke Elliott case for me. So
that's right.
So
you still owe me $15.
I want to ask about Brady won, what was it, 14 to 16 months for Deflategate in the federal courts. We saw that Zeke was a latest suspension for a couple months. Do you see that whether a situation where Watson gets 1 year suspension, it's upheld by Goodell, and how do you see the length of and the outcome of a federal case if it comes to it?
It depends on the ruling. Every time the NFL is over-disciplined with Elliott, Ray Rice, Adrian Peterson, Tom Brady, 4 out of 4 have ended up in federal court. And I think if we're talking about a 1 year or more suspension, it really depends on the grounds and sort of the timeline of how it happens. Is because if Goodell increases the punishment from what Judge Robinson had imposed, then you're looking at an all but certain federal court challenge. But if she imposes a 1 year suspension and Goodell doesn't increase it, I think it's going to be very difficult for the Players Association to find a sympathetic federal judge to overturn a disciplinary decision made by another federal judge who heard all the evidence, who could assess and weigh witness credibility. Where these cases fall up, where the NFL could get into a legal landmine is if there's some kind of procedural violation as to exclusion of evidence, denial of due process, or arbitrarily lengthening the suspension beyond that which was imposed by disciplinary officer Robinson. So if it's one of those 3 extreme examples, then you're definitely going to see this in federal court. But if it's Judge Robinson imposing a 1 year ban, Goodell upholding it, and that's the end of it, I don't see a successful court case. But the successful court case would likely come from any efforts by Roger Goodell to override the decision of a former federal judge and tack on additional games. Then you're going to see it in federal court before Labor Day.
You don't think it's going to end up in federal court? I mean, let's just say Watson doesn't get 0 games, right? Yeah, I saw one of our friends, and I don't want to call him out, but just predicted that the Watson will not appeal this, that it won't go to federal court like we saw with some of the Brady cases and the Zeke case. Dan, is that your also prediction? I tend to think, and we've hit it a lot, but I think these arguments about the owner precedent, I don't think the NFL is going to want this thing out there, right? I think it's in there, and we should also mention, this case could also settle at an amount, right? It could settle tomorrow, right? It could settle after the hearings, during the briefing stage, if there is one. And maybe Watson is inclined to appeal, and then the NFL comes back and said, you know what, we'll give you a year suspension, we'll get rid of the indefinite length, just don't appeal it to the federal courts. All of those options are possible. But Dan, don't you think just in that, going through that decision tree, why would Watson, if he doesn't get exactly what he wants, 0 games, why would he not? Why wouldn't he challenge this to a higher level, be it Dell or to the actual courts?
Because the likelihood of success is 1 out of 100. Every time Jeffrey Kessler's filed a lawsuit, it's because something bad happened. There was a denial of access to evidence, due process, wasn't able to take Jeffrey Pash's deposition in Deflategate. The law firm wouldn't turn over the investigative notes of the investigation. In each and every one of these cases, something wrong was done by the National Football League during the investigative process. But all those issues have been cured in the new CBA. The new CBA guarantees the players equal access to the evidence. So if there's anything that the league relies on, they have to share it with the player, the accused player. So the grounds that were raised in Deflategate around fundamental fairness, they're gone now because of the way the CBA has been rewritten in Article 46. Now, if Judge Robinson were to just impose a lengthy suspension and say, well, the selective enforcement or disparate discipline issue, I don't believe merits a reduction of the suspension because this is a far more grievous situation. I don't think you're going to be able to disturb that in federal court because federal court isn't a place to have a second bite at the apple, to reweigh the evidence. And the judge here, Disciplinary Officer Robinson, is in the best position to assess the credibility of these other cases and these other incidents. And I don't believe a federal court judge in a later filed lawsuit is going to disturb factual findings. In fact, there's a limited basis under which federal courts can vacate labor arbitration awards, and disagreeing with the judge's reasoning or how she applied the law or applied the defense, she has all the power in the world here to either give credit to this disparate discipline defense or disregard it or minimize it. And there's nothing a federal court can do to unwind her decision-making around that issue. It has to be limited to failure, like just a manifest disregard of the law. And I don't believe I don't believe that the discipline or that the selective disparate discipline issue is one that rises to the level of manifest disregard of the law. I think as long as she considers it, that's enough. If she doesn't consider it at all, then there may be a basis for an appeal. But I think we're likely looking at a federal court challenge following any NFL efforts by Roger Goodell to increase the suspension after her ruling. If it's her suspension, I mean, what is the likelihood that a federal court judge in either Delaware is going to agree with Deshaun Watson's legal position that a fellow member of the Delaware federal judiciary got it all wrong? I think any decision made by Judge Robinson comes to federal court clothed with a presumption of correctness. And I think if there's going to be a grounds for a lawsuit here, it's going to be because the NFL screwed up in the way they handled the appeal.
Okay, so Dan, I have my pick for who's next. I've messaged them, Dan, but it is your turn, and
go ahead. You can pick the next one. Go ahead.
Okay, so we got 5 people that have requested. Calvin, I believe, has been up here the longest. Calvin's is waving at us, so I was going to pick you anyway. Calvin, you coming on? Dan, I think our next pick after should be our one Texans fan with their hands raised. I feel like they're going to want to defense here.
Deshaun Watson, he's pretty impressive, pretty damn impressive career. He's from Clemson, playing the Houston Texans. Pretty good, but I think Lamar Jackson, Baltimore Ravens, they got their number, man. So give me Deshaun Watson, give me Baker Mayfield, give me Johnny Manziel. Doesn't matter to me, man. The AFC North runs through Baltimore, Maryland. The bank coming to the bank, and we're going to see about that. All right, big trust. Thank you.
That was the best comment of the entire chat, and I have nothing to disagree with. I mean, honestly, Johnny Manziel. I mean, he's the guy who could still play. He's in like the fan-controlled football league. He's fantastic.
All right. Well, Dan, let me pick the next one.
Appreciate it, man. Let's go Baltimore.
Okay, thank you. That was.
Well,
All right.
Calvin,
So let's bring
you're
up
my favorite person of the night.
Let's bring up the other perspective from the Houston Texans. I assume this is a Texans fan. Black Texans girl, we're going to call you up. Thanks for holding on.
Good guess, Dan. Good guess that it's a Texans fan.
Hello. Are you there? Black Texans girl, unmute your mic.
We have a question. So we have to ask a question before we start. True or false? Actually, no. Let me rephrase. You can only answer this with a yes or no. Are you a Texans fan?
Absolutely. Die hard. Ride or die.
Okay. Well, that was the only vetting we needed. And Dan, take it away.
Yeah, I'm sure you're not going to like what I said about the Texans doing Cleveland down and dirty on some of the trade negotiations and failure to disclose some of their involvement. But I'll let you ask the question. Go ahead.
Well, actually, that is what I wanted to discuss. You presented as though it was fact versus alleged. It's like you made an accusation that they did something fraudful, which I don't know if it was or wasn't. And the example you used regarding someone buying a house, well, no one buys a house without having a house inspected. So there is some responsibility on the buyer. Here's the thing, and I'll put it, and I made this.
That's a good point. Great point.
I made this joke to a few Browns fans. One, it was a used vehicle you bought as is. If you didn't inspect it, if you didn't bring a mechanic to check it under the hood, that isn't my fault. My other point is there were 22 civil cases active. The Browns were competing with 3 other teams. They were excluded and jumped back in by making the financial contract offer that they made, because they were not number 1, number 2, number 3. They were at the bottom.
Yeah.
The fact, and they got asked this question at their own presser. Did you do due diligence? They said they did. You need to go and look at whoever you hired that did the due diligence. But my question is, if you were willing to trade for a player who has 22 open civil cases, I don't think, knowing that it's possible the Texans knew a little bit more, you were willing to trade for a guy who is accused of this type of behavior. So there is no secret. All of this is in the open. So
these are great points. Go ahead. I'll let you finish.
So I think what bothers me is that it somehow the Texans tried to cover it up and tried to hurry up and get rid of Deshaun and get the most they could out of him. There were 3 other teams that were willing to take Deshaun. It wasn't as though the poor Browns got, screwed, They overpaid.
Okay,
They overpaid to get him to beat the other teams and didn't do their due diligence. So, no, you can't come back and say, hey, you sold me a lemon. No, you didn't look under the hood good. And go back to the person who didn't look under the hood.
Yeah, but Black Texans girl, there's no amount of looking under the hood by the Browns that would have uncovered any level of involvement by the Houston Texans. Now, I'm not.
Well, I disagree with that. A simple thing is ask a question.
Well, the point is the Browns' legal counsel, when they were, or the Browns should have insisted on certain representations, is come clean with everything you know. What else do you know?
Exactly.
We're going to take a risk. There's going to be another shoe dropping. Can you tell us? Have you disclosed everything?
Right.
That's relevant?
So that's on the Browns. That's common sense.
Potentially, but on the same token, and this isn't just my accusation or allegation. This is New York Times reporting, and I read.
No, it isn't. No, it isn't. Okay, so is it true that it happened, or they're being sued? Because last time I checked, there's one person that's suing them, so it's alleged, right?
Yeah, but the law.
I think we might have lost Dan, but to Dan's point, this is New York Times reporting. Okay. So I think.
Oh no! Hold on. I can take. Let me answer this. You cut out. Okay, yes, because my wife was calling, and I had to. Don't tell her that I flipped out the incoming.
This isn't being reported, Dan. You're good.
I read the lawsuit. It included excerpts of deposition testimony where the Houston Texans head of security acknowledged that the Texans arranged for the hotel room. Provided some of the massage tables, presented, the head of security presented the NDA. Some of these not allegations, but there are excerpts of actual evidence included within this lawsuit. So yeah, it is alleged, but it's allegations that are backed up by documentary evidence, including admissions by the Texans head of security and even admissions by Deshaun Watson within his own deposition, and that's excerpted within the lawsuit that was filed against the Houston Texans ownership group.
Okay, but no, the way I thought I understood, and please correct me if I'm wrong. One, it was at the Houstonian, which is the country club.
Yeah.
So are you saying that the Texans set it up for him to have this type of behavior versus I have a star athlete, my franchise quarterback, who is wanting some downtime and hanging out at the club, and while in the process I'm there, I'm going to get a massage. Please tell me how the Texans knew Deshaun was being a perv. I'm just sorry. That's the best way I can
That's a
say
great way
it.
of putting it. I have 3 letters to say to you in response to that. And these you're making such cogent, great points. We don't have to agree on everything, but you've really defended your side very, very effectively. But I'll say 3-word response. How did they know? NDA. That's it. They presented Deshaun Watson with an NDA to give to the massage therapist. They placed down on the table. They were aware, presumably, that there were some accusations made on an Instagram page where somebody threatened to expose him for his behavior. The Texans scrubbed that from the social media page, and the non-disclosure agreement prepared by the Houston Texans is somewhat, I wouldn't say incriminating.
One of them,
certainly strong evidence as to one.
But here's
when you're saying one, what are you saying? One
NDA,
one plaintiff,
and it was
who I think
right. But y'all make it seem like it was some kind of ongoing type thing. Here's my thing: is I can sit back and say, in hindsight, which is always 2020, when Deshaun went to the head of security and mentioned that someone was threatened to out him, he could have inquired more and asked some questions, which I would have. That's just my personality. But at the same time, he probably overlooked it because it was Deshaun.
Okay.
Us looking at everything. I mean, think about it. If your franchise quarterback goes and says, hey, I need an NDA. No, not NDA. I have this situation. And his recommendation is an NDA. You think nothing of it. How do you know that he is not going to go and copy it and go and use it ongoing?
All right.
But here's my last question. I'll be done. And I do truly appreciate you all giving me opportunity to speak.
Anytime.
NDAs are not out of the norm. Celebrities and athletes use them. So it's not something that is out of the norm. The only thing that I could question was getting the NDA done after the fact, but not before the fact. So with him having that situation previously, he probably was thinking, quote unquote, the average person, let me protect myself in the future and have anyone who is working with me or on me, unfortunately, to sign one.
Okay.
That's not bad within itself. It's just because of the fact that he took it to a whole different level. Allegedly, that it looks bad.
Girl, this will bear out, or eventually we'll find out some more facts about this as it gets further in the litigation, the discovery process, and if other suits are filed. But these are great questions, and I appreciate you waiting so long.
Thank you.
Asking such thoughtful, sharp questions and calling me out on that. I still feel that there's, some potential culpability here, but you're right. There are allegations at this point, not, proven.
So if you have a really inappropriate username, as we've seen, Dan will actually just say your username.
Nothing inappropriate about it.
So, no, nothing inappropriate about it. But I think we've seen you tell there can be someone with an appropriate username, but you will use that name to refer to them as their first name. So if you do have an inappropriate name, like Zoidberg, right? I don't know, it's not inappropriate, it's Futurama, but Dan will call you Zoidberg. So we now know your tell for future people. Dan, I think you defended it well, but I think she made the correct points. Just so everyone's clear, right? We a lot of what we're getting from the Texans mentioned that New York Times report. But I will say one thing. I'll correct a narrative. And Marco, I'm calling you up right now as you come onto the stage. There was an inkling that the Texans were going to be brought into the case a year ago. Tony Busby had a statement that said, we're going to investigate what the Texans knew. And so anyone that said, well, I've known it all along, no, like Tony Busby said that a year ago. He just, for whatever reason, kind of dropped it. But we always thought, at least on our show, I always thought the Texans had a chance of coming in because they're a really big pocket, right? Deshaun Watson's worth $230 million guaranteed, plus what he earned previously with the Texans and all these different endorsements. But the Houston Texans, as an organization, right, they're worth billions of dollars. So in litigation, right, if you can find a really big pocketed defendant to put in, that's a little extra money on the side, right? And when these initial settlements were reported, those 20 out of 24, I didn't know if the settlement included the Texans or not. Now we obviously, I think, actually, Dan, I take one step back. We don't know if the Texans were at all in those settlement, those 20 of 24, because the only person that sued the Texans was one of those remaining plaintiffs who, in theory, would not have signed any type of settlement and release. So keep an eye on the Texans one. I think it's
let's try to bring in a couple of other callers. And by the way, callers, this is like Sports Talk Radio. Thank you everybody for your patience and staying here for as long. I mean, this is almost going on 2 hours, so we thank you so much for your staying with us for the entire episode.
Marco, you're up.
Hello, Dan. How you been, buddy?
My man Marco, behind the scenes, has been following this Deshaun Watson case probably closer than any of my followers. So shout out to Marco. You're on the ball. So I don't know what you do for a living, but I do know that you've been following this case very closely. So I always appreciate your updates behind the scenes.
No problem. I'm retired. I'm just relaxing now. But
you putting your retirement to good work following this case very closely.
Appreciate that. No, I really just had a question to you guys because I really have been enjoying what you've been doing lately on this case. On this Watson situation, Texan situation, if they are found to, let's say, how do I phrase it? If they are found to be guilty, or let's say, can they expect 23 lawsuits, or can they only expect lawsuits from the people who haven't settled yet?
It depends on the scope of the release that the 20 settling plaintiffs entered into with Deshaun Watson. And I don't see any reason why Watson would do anything to help the Texans by including any third parties within the scope of his release agreement. But I guess it bears watching. If any of the settling plaintiffs file their own separate lawsuits against Houston Texans, then I guess that opens the prospect up for maybe 24 potential lawsuits. But so far, we haven't seen any others.
With an NDA, though, couldn't they not testify or talk about the cases, or could they?
I guess that
the NDAs they signed with the 20 that did settle.
I'm sorry, we haven't seen the terms of the settlement agreement, and I don't know if you're talking about the NDA that would be entered into as part of a settlement agreement.
Yes, sir.
That's not guaranteed to be in settlement agreements. There's like a non-disclosure provision that oftentimes will be in a settlement agreement, and I haven't seen or am aware of any language that would suggest that they can't bring lawsuits against the Houston Texans because of a NDA between the plaintiff and Deshaun Watson. So I can't go beyond that without knowing the details of the settlement agreement.
Okay,
interestingly, and Mark, I can respond to that too. Dan, a topic that you and I talked on the pod, we're trying to just give you guys all the information we know in the case so you guys can be smarter and follow this case closer. And those coming late again, we host a podcast, Conduct Detrimental, all things sports law, Snyder, Watson, all the good stuff. Now, Dan, we talked about this early on. There was talk about settlement from both perspectives, and I think this is where Mark was coming from. I don't know necessarily who to believe, but that Watson's camp did not want an NDA because they wanted, at least the report said, they wanted to know how much money, the amount of money, they believed it was small enough that would make people think that this wasn't, claims weren't as bad as people might have thought. Now, on the other side, the reports were that Tony Busby's side, the attorney for the 24 plaintiffs, he's the one that wanted the NDA. So we have not heard one way or the other whether these settlements, these 20 of 24, these involved some type of NDA. But Marco, you were totally fair to think that that's what has occurred here because, as we know, right, this case has been leaked to the media by both sides, the Busby side, the Hardin side. I don't know necessarily who's in charge of the leaks, but we know one of them has been leaking. And you think that fact and the numbers involved with the settlement would have come out. To that end, just to put a pin in it, there was a report, I believe it was contained within one of the recent complaints, that the Miami Dolphins deal that fell through, that 18 of 22, each of those plaintiffs was offered, I believe, a flat $100,000. But, the NDA, all that stuff fell through. So, Marco, you're definitely not wrong, but, we'll see what comes out. If those numbers come out, it tells you, right, that the NDA is probably not in place.
Yeah, Dan, let's just take one more request. I know there are a couple of people waiting. We're almost
Thank you, Marco.
Thanks, Marco. We're at the 2-hour mark, and we let in Guiding Light, who I asked one of her questions already. She wants a second bite, or he wants a second bite at the apple. So I'll let in Guiding Light. How you doing?
I'm connecting him. Hopefully he's not another Ravens fan. That guy, I had a feeling he was going to go somewhere, but that was the cleanest way I thought he was going to go.
Yeah, Guiding Light.
You're up. Just unmute yourself. Zoidberg, I'm looking at you here with that Will Ferrell face. I'm ready to call on you, but don't disappoint me. Guiding Light, you just got to unmute, then you're good to go.
Thank you, guys. I appreciate the time and having me ask questions. My question kind of follow up with the one I DM'd you. If the Browns did consider getting some kind of, now I won't say rescinding, but compensation for not having the full disclosure of facts given to them and the NFL, which Black Texans woman did talk about, do you think they could possibly get maybe not any of the 3 first-round picks, but possibly the other 2 draft picks back? And also, my other question is about, I forgot what my other question is. I'll let you answer that one first. Maybe it'll come to me.
I think, given that Roger Goodell is going to mediate or decide any disputes between teams, one, I don't think the Cleveland Browns are going to file a grievance. And I raise it hypothetically because I believe that the failure to disclose this information that the Texans knew about and failing to disclose it during active trade negotiations about the same player and needing due diligence around this incident. I mean, all the investigation that they could have done wouldn't have uncovered the Texans' role in it. I think there was a duty to disclose here, but I don't think the Browns end up doing anything about it. And the main reason is I don't believe Roger Goodell would set the precedent here and alter the terms of a trade and set this precedent going forward where teams can try to wiggle out of trades based upon later discovered information. But I think this is a serious enough non-disclosure to at least raise the prospect of altering the compensation here, because it had the Browns knew the full extent of it, had the Texans disclosed these known allegations at the time, I think it would have given the Browns pause about acquiring Deshaun Watson, and certainly their willingness to pay that price may have been a major issue had they known what the Texans, even if it's a minor role, it at least gives some substantiation to some of these allegations because of the NDA, the setting up the massages. The role of the Texans, I think, was unknown to the Cleveland Browns during the time of these trade negotiations. I'd have to operate under that assumption, and I think that is material.
Okay. I do remember my second question now. Do you think I'm sorry.
Go ahead.
Oh, okay. I thought you had. I was going to say, given the amount of hyperbole that we've had about the indefinite suspension or a year suspension, do you think that's a way for the NFL to try and force Rusty Hardin and Deshaun's camp to get these other 4 cases settled so the Shield doesn't have a quote-unquote black eye?
Great point.
I'll take it. And I had some tech issues, so I'm back. But yeah, I think that's probably what's happening, right? This indefinite suspension or whatever you want to call it. And as we said at the beginning of this talk, a lot of semantics, but it's not really that different than what's happening with Calvin Ridley, except no one's making a big deal that Ridley has to apply for reinstatement. And we know that happens a lot, but the fact that they're phrasing it as a definite suspension, the way the media have kind of run with it, tells you that the NFL wants to apply this pressure. So, to the last part of your question, we've said this on our show, but if those 4 individuals didn't want to settle those cases back when the Dolphins trade was looming, right, and they don't want to settle the cases now, to me, right? Those people are not. I don't know. People can say I'm wrong, but Watson just got paid, $45 million. I don't think money is the issue here, right? These people just either think that they're going to get more money down the road, and that's not necessarily a wrong theory. When cases settle, a lot of cases settle on the courthouse steps right before trial or later on in the litigation. That number, right, that the defense is willing to pay tends to rise as we get closer to big events. So, right, could be depositions, could be motions, it could be trials. So those four don't want to get out yet. So really, it's not Watson's call as to whether those four will disappear. That's really on them. And this is a case about a he said, she said type deal. It's not really ripe for motion practice. The only way that a motion would get decided is really if there's no factual issues that a judge or a jury doesn't need to determine. And the fact that it's still a credibility issue, these cases aren't really typically decided on motion. So short of a settlement, these are going to get up to trial and then, probably settle beforehand. I'd be surprised if they got to trial, but, they're not wrong for thinking that more money is typically coming if you wait longer in the litigation. So you just got to stomach the pressure, though.
Yeah, Dan, I hate leaving people, hanging with these requests. I know I said that we wanted to end it with this one. Let's go a couple more minutes and just take care of Carlo.
Real quick,
and
if I may, I just want to thank you guys for having me on here, and you're always welcome to the OGs of Cleveland sports space.
Ooh, we'll take that invite.
What is that exactly?
That sounds like
it's a space.
Well, he can message us and I will plug it. But we should be invited to the OG space for the
intriguing. He's back. He's back.
Zoidberg, you're up next. Don't mess up, Zoidberg.
No, you gotta let him in.
Well, Guiding Light's about to go, and then I'm going to let my friend Zoidberg up.
Go ahead, Guiding Light. Did you?
I just wanted to wrap up real quick, give you a brief synopsis of our space. It's just a couple of guys that are old Cleveland Browns fans from way back, even before the move. And we try to talk about Cleveland sports of yesterday and today, and we keep it civil, not like some other spaces.
Ooh, shots fired. Okay, Guiding Light, I appreciate it. Okay, Zoidberg, listen, I looked at your bio.
Thank you so much.
I looked at your bio, Zoidberg, as I'm bringing you up. Listen, you have a tight leash here, okay? You have a fake name, you got a Will Ferrell face on. It says you're from a different country. You got a tight leash, but you've been waiting very patiently. But listen, I'm watching you. We got two lawyers up here. So
hey, what's up?
This is fair warning. And then Carlo, you're up next. Zoidberg, you're up.
Okay, you can hear me?
I can.
Yeah. Okay. Cool. What's up? So I'm from Sydney. I'm a very optimistic Browns fan, and look, you guys have outlaid really well. Sort of the president's all pretty murky and it can be quite dangerous. And look, we don't know what the severity of the punishment's going to be. Is that the finality of the consequence? So if the severity is, say, 6 games, which will be good, or indefinite, which isn't good, and he'll have to be reinstated back into the league. Is that it after that? I'm optimistic. It's a 5-year contract. I just don't know what happens if there is potential consequences after this punishment that I need to be wary of. Because look, I'm happy to push it back for a year, and then we've got 4 years, and let's go. But just didn't know if there was anything I should keep track of.
Zoidberg, I set the bar so low for you because the fake name, Will Ferrell face, I wasn't sure, but the bar was set low. So here's the interesting thing, and we should address this, right? If there, let's stick to the law, and then I'll give you our prediction. But unlike a court of law, right, a civil court or criminal court, which are bound by what we call, in the states, there's statute of limitations. It's a deadline by which you can bring a certain claim by. So. The statute of limitations for these, I don't know how many we're going to have, but we have 66 different masseuses over a 17-month period. That's just the number that was reported by the New York Times. We're not really going to know finality as to how many more people are going to bring legal claims for another couple of months. Maybe some have years. I'm not sure where these different incidents occur, depending on the state. But what Dan and I mentioned it in our last show. The problem for Watson, the NFL doesn't have anything that's akin to a statute of limitations. So let's say hypothetically, right? Watson serves his, let's say he gets a year suspension, goes back to the field. He's ready to play in 2023. And we wait 2-3 years. And then someone decides, you know what? I'm ready to come public with my claim. I'm past the legal statute of limitations to file a case in civil court or pursue some type of criminal complaint. But I'm coming public. and I'm going to go on HBO Sports with Brian Gumbel or wherever. I'm going to come public about it. There is no kind of temporal time deadline that the NFL can't suspend someone on. To Dan Wallach's earlier point, if it's a case that's pretty similar to these other ones, I think Watson will say, hey, I've already served my punishment. But if it's different, right, if there's something that's different about the subsequent claim, there's nothing temporally, from a time perspective, blocking the NFL from issuing a subsequent suspension. So that's the danger, right? It's a good life lesson. Don't get a certain amount of massages that you can't count over a 17-month period. I watched, I'm a big football fan. I watched the Browns press conference. They asked Watson, does that number sound right, 66 in a 17-month period? And he kind of gave a face, and he said, I'm not sure. Speaking with my lawyers, I'm not sure. I don't know. And it would be odd, right, if Watson kept a detailed spreadsheet as to every massage he had over that 17-month period. But short of those detailed records, right, I'm not sure how you would be able to get some finality. So that's, when Dan and I are joking about the Browns having this crazy risk tolerance, I hope they knew that number. The question that I'll pose to you, Mr. Zoidberg, Mr. Futurama fan, right, what do you think is more likely? That the Browns did their due diligence and they knew all of this stuff and they gave him $230 million, or the Browns didn't quite do their full due diligence? What do you think is more likely?
I definitely think they did their due diligence.
And you think they knew about all of this?
Okay.
I definitely think they did their due diligence. I think it's a risk. It was a risk and it was worth taking, but
Dan, we've got to move this along because I got to get going soon. We have Carlo and then call me Vito.
Thanks, guys.
Thank you, Zoidberg.
Our pleasure. Call me Vito with a late request, and no more requests, guys. Please, it's 2 hours. Let's let Carlo into the chat, and we'll try to bring it home with Call Me Vito as a bonus listener. Carlo, unmute your mic and fire away.
We'll make this the last one. Well, Dan, we have one guy left.
Call me Vito. I am Big Daddy Kane.
They're both up. This is the last one. You guys both. You're gonna step brothers this. You can do it at the same time. Matching tuxedos. Get behind one another. You can do the interview at the same time.
Carlo, you go first. Go ahead.
Hey, what's going on tonight, guys? I've been listening. Thanks for letting me in and extending the time a little bit just so I can speak. I really appreciate that.
I'm sure I wouldn't want to let you, after this long, there's no way I would let you hang there.
Thanks. I appreciate that. I was thinking, I think you guys have done a great job explaining the process and, any future things that could happen. And I'm just curious, what do you think Sue Robinson will end up ruling? You've probably already touched on this, and I apologize, but she really seems like the wild card here, where the NFL wants this and the Players Association wants this, but what does Sue Robinson want at the end of this?
Well, she's going to hear the evidence, and I think the high likelihood is she's going to find that the NFL has satisfied its burden of proof, which is the credible evidence standard. I mean, come on, you have police reports, police insert reports, witness testimony of all these documents and records and interviews. Certainly within that, that evidence is enough to clear the bar for credible evidence. So now we're just really talking about the severity of the suspension. And I believed all along this is the real issue in the case. Does she look at comparisons to the owners, or does she just consider it solely along the lines of what the gravity of the offense is? And if we're looking at 5 women, and there's credible evidence as to all 5 women, I don't see how he gets out or gets away from this with anything fewer or less than an 8-game suspension. And I believe where the disparate discipline issue comes into play would be on anything above 8 games. The further you get away from the zero benchmark of Snyder, Jones, and Kraft, it really begins to look like disparate punishment. But if it's 6 games, 8 games, somewhere in that range, you really can't bind the disciplinary officer and tell her, well, you can never discipline anybody or give out any suspensions because the NFL sat on its hands with Snyder, Kraft, and Jones. So I think she strikes a balance here and doesn't give an extreme amount of punishment in deference to the non-discipline of the other owners. But I think she's going to give them 8 games, somewhere in the 8 to 16 range. I think that's what we're likely looking at.
We've said it on our show, over/under being 10.5. Dan's a big sports betting guy, and we get in the weeds. Okay, before we get to you, Call Me Vito, big thank you to everyone. Our podcast is called Conduct Detrimental. Follow the podcast, follow us. We are covering this case very, very closely. We'll put whoever missed the beginning of this, it's 2 hours. We're going to try to put this feed on our podcast so you guys can hear it in its entirety.
Like
when we do stuff
five
like
episodes. This is like 5 episodes.
Yeah, we'll fit into one. When we do this type of stuff, we've done St. Louis Rams Town Hall. We did a conduct cast of the, similar to the Manning cast we did at the Snyder hearings. We always get nervous that people in the crowd are going to say, stupid stuff. And we've had bombers before, but so far, no bombers. Everyone's asked good questions, with the exception of the Ravens fan. That wasn't really a question. He was just cheering for the Ravens. But call me Vito. Listen, don't ruin it here. We got a perfect streak going. We got a perfect game. If you were a good guest here, we will call it a night on you, my friend.
I believe in him.
How you guys doing? Thank you for letting me speak. I appreciate it. I just wanted to know you guys' opinion. Why do you think Busby added the Texans to the lawsuit? There's been, things going around. I've been in Texan spaces, Brown spaces. I'm a Browns fan. People think that he did it for power. He may be trying to run for office later. They think he did it for money or wanting to hold everybody accountable for Watson's actions. What do you guys personally think on why he added them so late to the lawsuit?
I can. Well, we talked about deep pockets, number one, but I think if you followed Busby, and it sounds like, Vito, you have been, Busby's, you can say a lot of negative things about Busby, but what Busby is good at is grabbing the headlines and capitalizing off them. That New York Times report, right, that came after, it was the same week or within a week of those, the happy endings comments, which didn't really look good for the Watson camp, and then that Jenny Brentis report from the New York Times. There was a lot of momentum that was all of a sudden on the accuser's side, which they had been losing since those indictments. So I think Busby needed to act to get the headlines back. And I think that's why he did it. I mentioned he'd been investigating the Texans for some amount of time. I remember he said it in a press conference that we're looking into the Texans. So, we talk about due diligence, right? Maybe that the Browns didn't do full due diligence. Busby was looking into this, and it took the New York Times reporting for him to come forward with those claims. So I think it's a matter of winning the headlines, and I think bringing, everyone in this chat, I don't think has Watson fatigue because you guys are listening to us for 2 hours after a year and a half of coverage. But the general public, outside of the diehards that are listening to this, they've had Watson fatigue, and they just hear story after story after story with still no suspension. The Texans being added to the lawsuit is a very different dynamic to the case. And all of a sudden, mainstream media was all of a sudden paying attention to these lawsuits again. That's why Busby did it. But Dan, go ahead.
Well, I mean, the plaintiff's lawyer is going to add whoever he can collect money from, and if there's any evidence that the Houston Texans aided and abetted Deshaun Watson's illegal activities and were involved in some part, why wouldn't they take a shot at it? And the basic argument is that Watson was acting, within the scope of his employment relationship. So if he's liable, so too are the Texans. And the Texans are, as a franchise, are worth over $2 billion. And why wouldn't you bring a lawsuit given what has come out about the Texans' potential role in aiding and abetting Deshaun Watson? And one of the advantages of having a corporate defendant, a multi-billion-dollar company as a defendant, is that in recovering punitive damages, you can consider the wealth of the defendant, and having the Texans as a defendant, as opposed to Watson, who's just a mere millionaire, a billionaire. You can go much higher in a punitive damage award against a corporate defendant who has committed a tortious act. So, it's sensible lawyering, and it's what any good plaintiff's lawyer would do when faced or when aware of allegations like this. I've got to ask you a question, though. I don't know if your name's Vito or just Big Daddy Kane. I looked at your pinned tweet, and it says Peter Millar suits only. I think I've got that sports jacket. Is that a Peter Millar sports jacket?
He's not on anymore, but I'm going to say it is for the record.
Okay.
Dan, we've been on this for 2 hours and 10 minutes. I checked the numbers.
Yeah.
Looks like we've had a couple thousand people turn in, which is pretty wild. Again, our podcast is called Conduct Detrimental. We cover all things sports and law. Our website is conductdetrimental.com. It was the brainchild of Mr. Wallach. Started a couple of years ago, and now we've kind of developed into a nice media organization following anything and everything sports law. Dan, I think we did a solid job. Appreciate all the questions. Dan, I'll give you the final words before we put this in the book.
No, I think, we've been on for 2 hours. We've covered the wealth of, items that could come up in connection with this hearing. I don't know what we've left out. If we've missed anything, and you're still left curious by how some of these proceedings will play out and what legal issues could come up, and just send us DMs and we'll try to address it on our next podcast or address it, in a direct message. Just engage us on this. We're like living this now day to day. So we love the passion and enthusiasm from the Cleveland and the Houston side. And
again, we were all set. I will say, if you do send us a DM, just like Deshaun Watson has learned, anything you DM can and will be used against you in a court of law. For everyone, the Conduct Detrimental family, for Dan Wallach, myself, we really appreciate everyone joining us today. Again, check out our podcast, Conduct Detrimental. Follow us here. Send us any questions you want. Free legal advice, free legal questions. I mean, what more could you ask for? I think we're good to go. Team, appreciate it. I see everyone in the crowd throwing us emojis. Much appreciated. Dan, you get the final word.
Let's do this again. I mean, this is going to go on for the next couple of days. If there's any kind of major development in the Deshaun Watson proceedings, it could be a ruling by Judge Robinson, it could be an appeal, it could be a federal court decision. We're going to cover this again, and you'll look forward to some more spaces around the Deshaun Watson disciplinary hearing. But I think now we wait for the decision.
All good. For all of us in here at Conduct Detrimental, we will see you next time on another edition of Conduct Detrimental Spaces. We'll see you next time. If you have hung with us for those 2 hours, we really appreciate it. You are officially a sports law diehard. You can collect your certificate at the door on the way out. So that was a lot of fun. Just making light here. Some tech issues. You didn't catch the beginning. When we started this Twitter Spaces, we had about 100 people join, and then we accidentally shut it down. That wasn't fun. And then at the end, when my kind of mic went crazy. But, we live and we learn. Our first Spaces, our first Conduct Cast, things are upwards and onwards. So, Mike, I think the most fun part for me, which is why I think we're going to do more of these spaces, maybe we'll do like one a month, is just like the wild cards from the audience. Like we had Zoidberg from, I think he was from Australia. He was a fantastic guy on the mic. But I have my pick. It is not Mr. Zoidberg with the Will Ferrell face. Mike, let me kick it to you. Who's your favorite random guest that we pulled up?
I didn't know what to expect at first, but I think I like the Ravens, Go Ravens guy coming in. He didn't have any questions. So he just kind of jumped in and was like, let's go Ravens. Down with the Browns. The Ravens are the best team. So I thought that was funny. My finger was like, I was monitoring all the speakers who were coming in, and I was ready to boot him as soon as he started kind of going off, but he was okay.
Can I tell you something? This guy, I think his name, I don't remember his name. It was like something with a C, but he was in since like the first minute, and he requested to go on stage immediately, and he kept raising his hand periodically. So I'm like, this guy's must got a good question. He keeps popping up, and he's like, he had a little bit of Coach O in him. He's like, let's go Ravens.
Yeah, he was definitely dedicated. His hand was up for a solid 45 minutes, and then he casually would do the wave emoji.
It wasn't really that bad, but so I'll tell you mine, Mike. Jokes aside, we had a lot of Texans and a lot of Browns fans. Those are the fan bases that I think are most curious about this. Obviously, the Texans being sued, the Browns, their quarterback is under fire here. My favorite exchange, and I know a lot of you had reached out, and a lot of people were using the laughing, crying emojis while it was happening. So. I can't speak for Dan, but we had someone in the crowd. It was obviously a Texans fan. They had a Texans, picture as their profile picture. And you couldn't see in their name, as Dan read it a couple times, was Black Texans Girl. That's their name. So sometimes you could just say, nice question, or I don't know, you don't have to say the person's username, but Dan was having a lot of fun repeatedly saying Black Texans Girl, which, I found to be somewhat humorous, but, at the end of the day, listen, she was my favorite. She came swinging, knowledgeable. She kind of called Dan out at one point for, we try to be very careful. Sometimes it's going to slip. All of the things that we're saying about the Texans are allegedly, because they're all from the New York Times report. But I think once or twice Dan might have missed it, but we've couched every time we say this, the Texans report, that's all allegedly. It's all a lawsuit, right? The burden's on the plaintiff to prove those issues. And Dan didn't back down, right? He said, some of this stuff is not allegedly from the New York Times report. Some of it's directly from the deposition testimony. So that was a pretty good back and forth. I think it was all respectful, but voices were raised. But I think it was all done really respectfully. And at the end, I think everyone was pretty happy. Some people pushed pretty hard. I think the Browns fans were concerned about their new star quarterback, how long he's going to be out for. And I think the Texans fans, rightfully in the chat, some of them were asking us questions. Why do we think that the Texans are going to be disciplined? And, we were just saying, if established, this is what's going to happen. But I thought she did a good job defending the point. She gets the point for my favorite guest. But we're going to do more of these. I just had so much fun with it. Honestly, we were going to go an hour, Mike. And, behind the scenes a little bit, my wife went out to dinner. She said, I'll be back by 10. So I'm like, okay, Dan, let's do the spaces from 9 to 10. 9 to 10 quickly turned from 10 to 11, and then 11 to 11:20. So let's just say, my wife is not too happy that I was doing a Twitter spaces at 11:20 outside our little girls' rooms. We have obviously a 2-year-old and a 1-year-old over here. So, but all in all, right, all for the cause, all for the brand, resulted in more media for the show and more spreading the gospel of sports law. So that part's great. Mike, I'm going to give you the final word on the spaces, but obviously thank you so much to everybody, Josina Anderson, AJ Perez, all of our friends joined. So we had a lot of fun and certainly going to do more of these.
I think it was interesting because we were having a good time. I don't think we anticipated, we didn't really know what to expect, right? We didn't think that people were going to, we knew that there were going to be people who were listening in, but asking questions. And then, we had our guy AJ Perez come in and ask questions. We had a lot of blue check marks that were kind of listening in and were interested in it. So we kept it going, and Josina was on there for quite a while as well. So I think she might have filled up about an hour. So it just had some good back and forth, good conversation, and we had such a deep dive that we just kept going.
I'm gonna tell people a little story, and then we'll call this episode. It's going to be our longest one in a year, but it's obviously an important case. We've covered it for a year and a half, so we have a lot of new listeners since February of 2021. We started covering this, so we thought it was only appropriate to give you everything. So we did our conduct cast last week when Roger Goodell testified in front of Congress, and we heard, Mike, this might be news to you. I don't think I've told you this. We heard through the grapevines that conduct cast, we had the live feed of the hearings, was actually being shown at Barstool HQ, not because Barstool gives a flying F about us, but because we were doing something unique. And, it got in the radars of the right people, especially when Portnoy was getting as mentioned in Congress. So I heard, Mike, through the grapevines, that there were people at NFL.com, an NFL entity, listening in on our show. So you never know who's listening, right? At one point, Mike, and you've been here since day one, since the Dan Wallach, Dan Lust era, we had, we'll say we have exponentially more listeners than we did back then. And that's because we take some risks, we take some shots and some topics that no one really else is covering. No one knows how to cover. And then you never know. You get one person telling their friend. So I don't know, the moral of the story, if you like what you're listening to, if you've been a supporter of us for a while, we love when you leave reviews. I know I read all the reviews that come in. I read all the tweets. I try to retweet them when people talk positively about the show, but there's no better favor to do for us than by leaving us a rating and maybe tweeting about us or telling a friend about us. So we thank everyone that's been along with us for this long journey of Conduct Detrimental. If you're listening to the end of this very, very long podcast, you are officially a sports law diehard. Again, collect your certificate at the door. Mike, I think we can end it here. I think that's a good point. Podcast, in addition to our friends at Underdog, is sponsored by Themis Bar Review, top bar prep company in the galaxy. Our next episode is going to be the next one immediately in the feed. We're going to get 2 episodes to people on this lovely July 1st. We're going to cover all the insane stuff that happened in sports this week, from USC, UCLA to the Freddie Freeman saga. We have a whole recap of the 1-year anniversary of NIL. So a jam-packed episode. So if you stuck with us all this time, you like lawyers talking about sports, please join us again and hit that subscribe button. Mike, I'll give it to you, buddy. What do you got?
Yeah, I mean, we are now hitting the 1st of July. We are in the final countdown for those who are studying for the bar exam. You mentioned this podcast is sponsored by Themis Bar Review. We hope all of our listeners have taken their chance with Themis. We love working with Themis, and we know it's going to properly give you all the tools and success to pass the bar exam. So, but if you are 2L or a rising 3L here and you're looking for your bar prep company for next year, planning ahead, just make sure you head over to themisbar.com/condetrimental, and you can check out all the information about Themis and their bar prep and some supplies for getting you through your 3L year as well. So good luck to those who are studying in the final stretch. Have a break for 4th of July, take a breather. I think it's good to kind of rest up and then right into the final stretch of the studying for the bar exam.
Mike, good way to end it. And if you are not in law school or did not go, it's not too late. Themis will hook you up if you do get to the bar stage. Okay, I think it's time to end it. Longest episode of all time. Mike, you're the man. Thanks, everybody. Thanks, Josina, to AJ Perez, and our thousands, crazy to say it, our thousands of people that showed up to a live Twitter Spaces. So I hope you guys enjoyed it. Again, more of these to come. And for Dan Wallach, myself, Mike, the Conduct Detrimental family, everyone writing for us, lovely articles at conductdetrimental.com. We will see you next time on another episode of Conduct Detrimental.